Just comb your hair, go and wash your face. It's been a real long time since you've seen the light of day. So let thoughts come as they may, beauty and parade. Everybody all smiles when you're back in the seat again. All aboard the petty express to a beautiful darkness. It's full steam ahead to ride the rails to our next destination. Yeah!
Happy Monday to everyone. I hope that everyone survived the storms last night. They were incredibly strong where I was. And I was really glad that Mr. Mo had gotten these dead trees taken down before all of these storms came through, because we might have had a tree fall down had he not done that. Okay, so you guys, we are going to finish up day 2. It looks like we have Dr. Markey coming up. Markey is the medical examiner, and we're finishing up with Verge Franks. He was a chief or a deputy sheriff, but he was like the shift manager of the deputies. So interesting that they haven't brought the detectives on yet or things like that, unless they're kind of going in a chronological order and doing the thing that prosecutors have to do. You know, this person touched the evidence, this person, you know, sealed the evidence, and then this person tested the evidence. Sometimes I do think that trials and courts could be made much more efficient, but I'm not a lawyerologist. Anyhoozle, let's get into this, you guys. I am going to put this at it is at 1.25. I am on top of things today. Well, sort of. But let's get started.
Was because I was a sergeant, basically a road sergeant, a patrol sergeant. Our criminal investigators, our detectives, that's their purview. That's what they're there for. So I did not usurp their responsibility.
Okay. All right.
No
Thank you.
usurping.
Ms. Zeidinger? No. Jury, any other questions of him? No? And you both agreed to excuse him from subpoena, correct?
Yes.
Okay, thank you, sir. You're all done.
Thank you.
Ms. Zeidinger?
Like, I'm
Your Honor, people call Dr. Michael Markey.
I do love her green dress. I really want a green dress like that now. Welcome Tammy Fayette and 80s Music Man, John Coman, and everyone.
Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. And you get settled in. If you could give us your full name and spell the last, please.
My name is Michael Allen Markey, M-A-R-K-E-Y.
Thank you.
Dr. Markey, what is your current occupation?
Wait a minute. How did the guy from Scrubs get here? Okay, no, I don't want to use my mic. No, I don't, none of that. Google, I hate you. Okay, because I'm having a total brain fart, but how does this man look exactly like... Come on, internet, don't be dumb. Okay, how does he look like Dr. Perry Cox? Or, you know, if you know him from Ice Cube's Are We Done Yet? But how did the medical examiner look like this man? How does this happen? How does any of this happen? 2024, you are trying to kill me with absurdity. Or no, you're 2025. That being said, how? How does this happen? So, back to this tab, and the man looks exactly like him. Look, I do not lie. Welcome, Shannon in Arizona and Alice G. So I did get some Okay, you guys, I am going to be really honest with you, and I'm noticing it myself, but this is about the most cleavagey shirt I have ever worn. Now, that being said, I'm not, against women showing cleavage. I just, for a long time, have not been so comfortable with my, body shape. So, now I'm branching out and getting out of the, tent wear, and I'm like, oh, I had a waist. Who knew? So I might be zhuzhing up my look from here on out, because all of the dresses that I bought in fall don't really fit anymore. Like, to the point where the elastic, where it's supposed to kind of make a beautiful drape, effect on you, it doesn't even hold up. No, you don't. All right, no, we're naming and shaming. Come here. Hello, my name is Loki, and I like carbs. I like to eat carbs. If you have a French bread out, I will eat it. If you have a bagel out, I will eat it. I will, in fact, gnaw through the plastic wrap from anything that's a carb from the bakery. And I was just about to eat the, rolls for tonight's shredded steak. He's like, I is not bad. I is not bad. I is just loving carbs. I is a fat. I just need a carbs. He's like, leave me alone, ma'am. You distracted me and I couldn't get my carbs. How dare you?
I'm a physician, more specifically, I'm a forensic pathologist.
And what does a forensic pathologist do?
Forensic pathologist is a physician that has specialized in the field of pathology, which is essentially a branch of medicine that utilizes examining body tissues, either the whole body tissue or tissues removed at biopsy or surgery to make diagnoses. Forensic pathology is a further subspecialty of pathology in which the pathologist has additional training in performing autopsies, especially forensic autopsies, those that fall under a medical legal death investigation purview to determine the generally cause and manner of death.
And how long have you been a forensic pathologist?
I've been practicing as a forensic pathologist since 2002, so 23 years.
And how many autopsies have you performed?
Several thousand.
And as part of preparation for today, did you give me a current curriculum vitae?
Yes.
And, Your Honor, may I approach? Can you just look through this and see if you recognize that?
Ooh, he has gold glasses. Fancy.
Yeah, that's actually an older copy of my CV, but this was actually from back in 2009. But it would have been accurate as of.
And welcome, Veteran Nation Raiders. I hope you are having a great Monday. We are hopping back into the Michigan versus Linda Stermer retrial. Linda is accused of bludgeoning, torching, and running over her husband. Now, the defense claims that the fire and all the bludgeoning were accidental or, a work of God, and running him over was also sort of a mistake because he didn't stay where she had propped him up. This case is ridiculous, ridiculously hilarious, although it has no right to be because someone unfortunately lost their life. But we have had such gems in this trial as, well, he magicked himself under the car wheel and she just magically ran over him. We've also had scintilica, a word that we didn't know was real, but now definitely is. And of course, grotesque. We also have one of the defense attorneys who is trying to out Shatner, William Shatner. So welcome everyone. I hope that gave you a little bit of an idea of what we're getting into today. This is day 2. We are a little bit behind. I was planning to catch up during yesterday evening, but the storm kicked my behind.
That time.
Yeah, at that time. And so that is a copy of your curriculum vitae?
It is. It's not the most recent one. I do have a recent one with me if you would prefer to have it.
And I think we're fine even just using this one. And I believe at this time, both counsel have stipulated to its admission as People's Exhibit number 4.
Any objections? No, it's good. Court will receive People's Exhibit 4.
Thank you, Your Honor. Permission to just publish. And on that curriculum vitae, it lists out all your professional experience up till 2009 and pretty much your education and your role.
Yes.
And you've remained in that role from 2009 until current, is that?
Can I rant for just a minute? Y'all, I looked at my weather profile today, and not only did it say it was going to rain, but it was going to rain Wednesday, Thursday, Friday, Saturday, and Sunday. Now, that would have been good. That would have been good, except for the fact that rain bothers the ever-living schnell out of my leg, and I have so many things I want to get done this weekend. So, I am irritated with the weather. That is all. Just thought you should know, in case you were wondering how I felt about this current weather. It's a hard RSVP no on that one.
Correct?
Yes.
And as part of in Your Honor, at this time, I would also move to admit him as an expert in the field of forensic pathology.
Any objection, defense? Okay, we'll receive his testimony as an expert in the field of forensic pathology.
Thank you, Your Honor. On January 8th, on 2010, did you perform an autopsy on Todd Stermer?
I think it was in January of 2007.
I'm sorry, you were correct, 2007. Thank you for that correction. Was that the first time that you had ever seen Todd Stermer?
Yes.
And can you describe how a body comes to, actually, let me ask you this first. Where are you currently working?
I work at the University of Michigan Health, Sparrow, Lansing, in Lansing, Michigan.
Is that where you were working in 2007 when you did this autopsy?
Yes, it was called Sparrow Hospital then, but it's the same place.
So can you explain to the jury how the body arrives when it arrives to your facility?
Right, so both then and
Hopefully
now.
dead.
In this specific instance, I wasn't the medical
And thank you, Dwayne Rapp, for gifting 10 memberships. And those went to NZ Kiwi NZ, Graceful Klutz, Rachel, Anders Gustafson, Medita Finn, Storybook Doll, Moonfox Studios, Bree H, Observation Station, and Chrissy Bacon. So congratulations. Welcome to the Church of Mo. We have dark chocolate, sarcasm, dark humor, but no plastic recorders. Look, those things are audio assault weapons, and we will not be handling those. But thank you, Dwayne, for your support of this channel. I appreciate it. Let me get those tickets written up while we listen to this man.
examiner for Van Buren County. I was serving as a consultant forensic pathologist. So when the medical examiner in Van Buren County needed an autopsy performed to fulfill their duties, the body would be sent to Sparrow Hospital by a transport service, logged into the morgue, and then one of the forensic pathologists there would subsequently perform the autopsy. On this date, I was assigned to autopsies in the morgue, and I performed the autopsy.
So does the body arrive in a body bag?
Yes. So typically, the body is within a zippered body bag. Many times, there's actually a seal on the body bag to indicate that it was sealed at the scene and that it's still sealed when I open it, and it will typically also be labeled, usually with an identification tag indicating the individual's name.
Is that how Todd Stermer arrived in this case at Sparrow?
Yes, I believe he was in a body bag, and the tag on the body bag and on the body itself actually indicated his name.
So when you begin your autopsy, do you have to break that initial seal?
Yes, I oftentimes don't. I have assistants that assist me with the autopsy. They often actually do the breaking of the seal, but it's not broken until the autopsy is scheduled to begin.
And what is the purpose of that seal?
The seal is just for preservation of what we would consider the chain of custody. It gives me confidence that no one has entered the body bag and altered the body in any fashion prior to my examination.
And do you recall how long this autopsy lasted?
Boy, it's been a long time ago, so I don't.
Y'all are doing awesome. I started filling this in January, and we are nearly full of the curse jar of tickets for memberships and super chats and everything else. And you guys, I bought 2 packs of 200 tickets, in January, and I am already needing to order more. I actually will have to write down the rest of the super chats today, if I get any, because I am out of tickets. So thank you guys so much. It is incredibly supportive, and hopefully I give back to you guys just as much, because you guys have all really just been so supportive in this dream of mine. So thank you guys so very much. All right, so let's get into autopsy talk with Mo. Mo in the deep end, autopsy talk.
Typical autopsy, that's, would usually take me a couple of hours. So my guess would be at least a couple of hours. It may have been a little bit longer, given the type of case that this was.
And you said that this took place at Sparrow at that time?
It did, yes.
Was law enforcement present for the autopsy?
Yes, according to my report, which I've reviewed and brought a copy of, there was I believe, a detective with the Van Buren County Sheriff's Department that was in attendance at the autopsy.
Did you release items to law enforcement at the conclusion of that autopsy?
Yes.
And do you recall what items?
There were some items of clothing that were released, I believe, fingerprints that we took at the autopsy of the decedent's fingers. I believe a DNA card prepared from blood that we collected at autopsy, and typically we would have released a copy of the photographs of the autopsy that we took at the time.
Do you recall, or do you have it in your report, of if the body had any clothing on it when you first observed it?
Yes, the only clothing that was
Permission
being worn
granted.
on the body were 2 socks, one on each foot. There was additional clothing that was with the body. I believe there was a pair of underpants. They weren't on the body, but they were in the body bag with the body. And then there was some sort of long sleeve shirt that wasn't being worn, but that was sort of draped over the front of the body, covering sort of the torso and genitalia area.
Do you recall any sweatpants?
No.
And that those items of clothing are then what you were talking about when you said clothing was released to law enforcement?
Yes, the clothing that was present.
And thank you, Tim, for gifting 1 membership. And that went to Utterly Ridiculous. Oh my gosh. Oh my Bob Ross, do I love that name. And I will have to put this on a handy dandy yellow notebook because I am all out of tags. Now, it could be said that I might have lost a couple packages of tags as we have been, redoing my entire room. But, I mean, we are just cooking with gasoline today and this whole year. And I'm feeling like hopefully spring will be done or be started soon. Because look, y'all, I don't look good in orange. Y'all know this. Y'all know this about me. But if that MFing groundhog sees his shadows, look, I'm not saying I have a Ford Econoline van too that can carry 10 people. And we will take Puxatawny Phil and we will get him, used to the light. Because I'm just saying. And thank you, the Wilborns. I hope you are having a lovely day. I am just hoping that maybe we, we get some spring started.
When the body was received in the morgue.
Before starting an autopsy, is there a particular procedure that you follow?
Yes, so I have some idea as to the circumstances. Any history that's provided, I try to review ahead of the autopsy. Any investigative reports, either from the medical examiner's office or from investigating law enforcement, if there's any medical records that are present, anything that may give me an idea of, what the person's health history is and what the circumstances around their death were. Were they in a car crash? Were they apparently shot at? It somewhat alters a little bit the procedures that we perform during the specific autopsy.
So you were aware of some of the basic facts of this when you started your examination?
Yes.
Do you recall what basic facts you knew at that time?
Yeah, very basic. I knew that he had been in a house fire and had been found outside, and that he may have been struck by a vehicle after the fire.
Can you explain to the jury what your initial observations of the body were?
Yes, so the first observations of the body are, as it's received to me. So he had the clothing on and with him. There was some evidence that they had attempted to resuscitate him. I think he had a small catheter in his neck from, EMS attempting to establish an airway. I think he had some defibrillator pads and maybe an EKG pad on him. I think there might have been an IV in place. I'd have to look at my report specifically. But there was evidence that he had a resuscitation attempt. He also had obvious diffuse burns over the majority of his body.
And when you say the majority of his body, can you give me an idea of percentage?
Yeah, it was probably over 90%. The only place that the skin was still relatively intact and somewhat normal were on his feet, where they would have been protected by the socks that he was wearing, and I think a little bit more on one of the legs, like maybe up to around the knee, but it wasn't all intact. It was just partially intact there. I think for the most part, the skin was generally burned and the surface skin absent over the rest of the body.
Did you observe any sort of lacerations?
Yes, he did have some what we would call blunt force injuries, so injuries caused by impact with a non-sharp object or a blunt object. He had lacerations of his head. There were 4 specific lacerations. One was on the top of his head, one was on the back of his head, and there was one on each side of his head, generally above the level of the ears.
Okay. So that's not sus whatsoever. I'm sure that he could have fallen down the stairs and boinked his head, only 94 times, as one does. I say that with all, condescending reality when I would fall up the stairs. He's going to say about enough times to make me want to lose my mind. So he, above the ears, had one in front, back, left, and right. So he had lacerations all around his head. Now, if you're able to get, all 4 corners of someone's head, that doesn't seem too random. I mean, this is like Stacy saying, oh, well, it wasn't an act of, trying to actually aim when I was stabulating. I'm sure the defense will magic this away, magically. And
there were also larger lacerations or skin tears. That's basically what a laceration is, a skin tear or skin split. One was on the inside of his left upper arm. One was on kind of the right upper back of the shoulder area. And then there was a smaller, more superficial one sort of on the lateral or left side of his chest and back.
What was the largest of the lacerations on the head?
There were 2 lacerations that were around 2 inches, maybe a little over 2 inches long. Those were the ones that were on the top of the head and the back of the head.
Once you complete then your first examination of the body, then what's your next step?
So essentially, the next step is removing the medical devices, removing the clothing, removing anything that may obscure the body examination. If the body has any blood or dirt or anything else on it that may be obscuring my ability to see what's on the surface of the body, that's removed. So generally, medical devices are removed, clothing is removed, the body's cleaned up, and then basically the same sort of examination is done on the external surfaces of the body, now with just those materials removed. In this case, there wasn't much to remove, so there wasn't much additional to see on the external surfaces of the body.
And then what would be the next step after you've done that initial?
Right, so the next general step is the performance of an internal examination. So after we've looked at the outside of the body, now we make incisions, just like surgeons do in the body, to expose the body cavities and the organs in the body. So incisions are made on the chest and abdomen to examine the internal structures of the torso. A reflection or an incision is made in the scalp to expose the skull. A portion of the skull is removed to examine the brain, and then the neck structures are exposed and examined.
So as part of your internal examination, do you document then your findings?
Yes, so I would document the general appearance of the organs, any evidence of natural disease involving those organs or tissues, and any injuries that I can appreciate.
Your Honor, may I approach? I'm going to show you what's been marked as People's Proposed Exhibit number 5. Can you tell me, after looking through those pages, if you recognize this?
Yes, this looks like a copy of the autopsy report that I authored following the conclusion of the autopsy. And there are actually 2 page 8s in here, but there's a total of 9 pages. And attached to that is the toxicology report.
And is that toxicology report part of your medical documentation with the autopsy?
Yes.
Your Honor, I would move for people's admission of People's Exhibit number 5 at this time.
Your Honor, if I could see that, I just want to clarify something with counsel.
Attorney
We're good.
you know, the rock.
Yes, Your Honor. This is People's Exhibit number 5.
Thank you. We'll admit people's five.
Thank you. And I'm going to go ahead and put that, permission to publish, I'm going to put it up on the screen so that we can discuss your findings. So what I'm showing is this, what you have is page 1.
Gregory, it's actually neither. This is a continuation of day 2. I am finishing up day 2. Now, they should be on day 3, but I was told that because of all the different things that were happening in the trial, that there was not going to be a Monday today. So I am trying to, you know, look that up because it doesn't look like there is anything that is starting today. So there has to be something that happened in this particular, you know, mid-morning to afternoon that completely, you know, oh, it is some kind of holiday? Well, my kids had school. That's fair too.
Yes.
And can you go through what we're looking at here on page 1?
Yes, so at the top are just the demographic information, the patient's name, the case number that was assigned to it, date of birth, his gender, when the autopsy occurred, who was present, etc. I already see that, unfortunately, I made a typographical error on the date of his death. It should be 2007 and not 2006. I must admit I'm pretty slow at my year changes when the year changes from one to the next. And then after that is an outline that lists the diagnostic findings of the examination. So it's essentially this page, and what spills onto the next page is a summary of the diagnoses that are described in more detail in the rest of the body of the report.
So it looks like on paragraph number 1 with the thermal injuries, we've already then discussed that. Is that correct?
Yes, I diagnosed thermal injuries, what are more traditionally known as burns, over most of the body. In addition, he had evidence that he had inhaled what we call products of combustion, which are materials that are produced when something burns. So essentially the smoke or the soot, the gases.
And is that a significant finding in terms to maybe timing of death?
The inhalation of products of combustion are, at least in my field, when we're examining a burned body, one of the questions is whether the person was alive or not during the fire. And finding evidence that they inhaled the smoke and soot, the products of combustion, indicates that they were alive and breathing at the time that the fire was occurring. So the fact that there was evidence that he inhaled such products were indicative of him being alive at the time of the fire, and also may indicate that he may have had some inhalational injuries as well, or injuries related to inhaling the smoke and soot.
And if we move then to the section number 2 on the blunt force injuries, I believe you've talked a little bit about that, but can you go into a little more detail? It appears that there's a little bit more explanation and some additional findings.
Right, sure. So under Roman numeral number 2, capital A, are the lacerations or the skin tears that were on his scalp. Beneath 2 of those lacerations, the 2 that were on either side of the head, there were very small, about 1/4 to 1/2 inch length indentations. Some might call them depressed fractures of the skull. They were very superficial, and they just involved the exterior surface of the skull. So underneath 2 of those lacerations, the skull was, for lack of a better word, had small dents related to the impacts. But there were no internal...
Yeah, I think it's... Okay, I'm going to butcher this, but Eid al-Marik? It's the end of Ramadan. Look, I'm not going to try to butcher names. I don't need to get arrested in the UK. So, that being said, congratulations, you no longer have to fast, and I hope you had, you know, a spiritual experience while fasting. I don't know. Look, we have Lent. I know more about Lent, but congratulations.
Injuries in the brain otherwise. The brain itself looked normal. There was no bleeding in the brain or around the brain to suggest a brain injury. Capital B lists superficial linear abrasions. So abrasions are essentially scrapes or scratches. So it's a blunt force injury generally caused by friction. So classic examples, if you fall onto like the sidewalk and scrape your knee, that's an abrasion. If you had lots of linear, which means line-like abrasions scattered around on various surfaces of the body. There were the lacerations of the right shoulder, or upper back, the left upper arm, and the lateral left back and chest, which I noted earlier. And then there were a couple of other internal injuries that I only saw when I examined the internal aspects of the body. There were fractures of 2 ribs on the left side, left rib number 3 and 4. They were fractured in what I describe as the anterolateral position. Antero means front, posterior means back. So they were on the front side of the back, but closer to the outside of the chest than the midline of the chest. Those types of fractures can be seen.
So what he's talking about would be sort of the outside of the rib still in front, but it's going to be away from the median aspect or your belly button. So these are cracks right about here to the side. They're not going into your back. Now, I do wonder if those were cracks that would be present if people did try, CPR. If you really try CPR, there's a good chance that with the pressure you have to put on that you are going to crack some ribs. So I do wonder if the defense is going to bring out that, on the left side on ribs 3 and 4, were those fractures maybe correlated with, CPR. And thank you so much, Tammy Bogard.
With chest compressions during CPR, it's where the ribs kind of bend when you're pressing on the chest. There was one right rib that was fractured, right rib number 3, and it was fractured posteriorly or on its back aspect. And then the only other internal injury that I appreciated was focal hemorrhage or bleeding in the tip of the tongue.
So I just want to ask a few questions about some of those. You had
Okay, you guys, here's where I'm having a problem with she done runned him over. As funny as that is as a, sort of gag, I would assume that if you had run this man over several times, unless he's going to get into, there were fractures of the leg, there was fractures of the pelvis. This is a remarkably unbeat up body for having been, under the wheel of a 1993 Econo van. Now, that being said, I'm not a doctorologist, so let's continue.
had mentioned that the shallow depressions, those were shallow depressions in the actual skull bone.
Yes, in the bone itself.
And you said that some of the rib fractures may have been caused then by, or what you typically see in chest compressions. Is that correct?
Yes, obviously I can't tell exactly what caused those rib fractures. There are multiple ways that ribs can be fractured, but in my line of work, we see many people that have had chest compressions before they die.
May have been caused then by, or what you typically see in chest compressions. Is that correct?
Yes, obviously I can't tell exactly what caused those rib fractures. There are multiple ways that ribs can be fractured, but in my line of work, we see many people that have had chest compressions before they die, and it's not uncommon to see fractures in those locations during those situations.
Were there any rib fractures that he sustained that would not have been something you commonly see with CPR?
Yeah, the right rib fracture, the fracture that was in the back, would be uncommon to be seen during CPR. Generally, you don't fracture ribs in the back when doing that.
And I believe we've covered all of those on the injuries. And I want to just clarify the blunt force trauma.
Oh, okay. Well, Denise, I did not know that. I just know that when, and this has been many moons ago, when I was practicing for CPR, I was always doing it too lightly. So I was told to really press down and not to worry about it. Basically, my instructor said, well, would you rather have a broken rib or, be passed away? So I was one of those maybe dainty pressers. Now, the depressed skull fractures, I need someone to explain those to me. Even if they were as superficial as a depressed skull fracture can be, the fact that he has top of his head, side of his head, side of his head, and back of his head, along with some scratching to his shoulder, into his back, up on his chest. Yeah, I have some questions.
Again, how is blunt force trauma, how does that happen to a patient?
So a blunt force injury is one in which something that's essentially blunt or not sharp impacts the body, or the body impacts such a surface. So being struck with something like a board or something that's not got a sharp edge will cause a blunt force injury. And classic blunt force injuries are either abrasions, scrapes, contusions, which are bruises, or lacerations, which are skin splits or skin tears. Conversely, if part of the body strikes another object that's blunt, you can see the same thing. So if you fall to the ground and hit your head on the floor, you may end up with a bruise or a laceration. So it's either something blunt striking the body or the body striking something with a blunt edge or a blunt surface as opposed to a sharp surface.
And you said there were no injuries to the brain or brain bleeding associated with the skull depressions. Is that correct?
That is correct.
Is it possible to knock someone unconscious with a blunt object and not have bleeding or brain injury?
Yes, I mean, that's essentially what a concussion is, where you have an alteration in consciousness due to an injury that typically isn't necessarily caused by some obvious visible injury to the brain.
I want to, and I apologize, I forgot to ask you a question with the soot in the airways. You said that it indicates he was alive at the time of the fire, correct?
Yes.
And is there some sort of relationship to the proximity of the fire that you look at in terms of the amount of the soot in the lungs?
Well, I'm not sure. I understand the question exactly, but the more smoke and soot that's being produced by the fire, and the longer you're in that atmosphere breathing it, the more soot you're going to have. So, for example, many individuals that die in house fires don't really die from burns. House catches on fire, they get away from the actual flame fire itself, but they're in an environment where they're breathing in lots of the smoke and the soot, and they die essentially from inhaling the products of combustion. In those instances, usually there's a large amount of soot, black material, in the nose, in the mouth, in the airways, and when we measure at least one of the gases that's present during fire, specifically carbon monoxide, when we measure concentrations of carbon monoxide in those individuals who die under those circumstances, the carbon monoxide concentration is usually quite high. In individuals who are not in a smoke-filled environment very long, would expect to have less soot and therefore not as much carbon monoxide and other gases present. It's also been my experience that when an individual is on fire, as opposed to just being in a fire, they tend to inhale less smoke soot. We give off less products of combustion when we are on fire than, let's say, this building with all of the wood in it would. I don't know if that answers the question or not.
Yes, it does. Thank you very much. And as part of your report, did you determine the cause and manner of death?
I determined the cause of death were thermal injuries or burns and inhalation of products of combustion due to the fire. Manner of death is something that goes on the death certificate that the medical examiner in each county is responsible for filing. It's essentially for public health and data collection. It's not really supposed to be a determination of legal or judicial responsibility for the death. In this case, because I wasn't sure at the time of the autopsy and at the time of issuing my report, the exact details of how the fire was started, how he came to be burned, I offered my opinion to the medical examiner here in Van Buren County that I would classify the manner of death as undetermined.
And that's on your report?
Yes.
I believe he is a pathologist with forensic upgrades, I guess, but he is also the medical examiner. So he is the one that is explaining how Mr. Todd Stermer passed away. What I will say again is I am struck by the lack of internal injuries. If the state wants me to believe that he was run over several times with an Econoliner van, a basically 10-passenger van, and all he had was 3 rib fractures, several slightly depressed skull fractures, I have a hard time marrying the two together. Now, maybe the state is going to bring out that, if you manage to get between the wheels and just go under the undercarriage, then you could have less injuries. I don't know. I will say it does give me doubt. It does make me pause. And good morning, Erica.
And so then that is on the page that you have, I'm sorry, what page number is that?
Yes, that opinion
page number
is
2?
is on page 2.
Okay. Pardon me?
Jury might be passing it around.
Oh, no, I actually have it up on the screen too. Thank you. So I just want to give you a hypothetical. So if somebody is standing out in the middle of the road and is hit by a car and you do the autopsy, would it be a very similar sort of manner?
Yeah, again, it all depends on the circumstances as I know them at the time. So if someone is found dead in the roadway and I do the autopsy and they have lots of injuries that are consistent with being struck by a vehicle, the cause of death is fairly straightforward. He died of those injuries, blunt force injuries due to being struck by a vehicle. If I know no circumstances whatsoever, or the circumstances aren't very clear about how he ended up being struck, then I would typically give an opinion that the manner of death is undetermined. I don't know the circumstances around which they happened. Now, if it happened to be witnessed, or it's on video, or there's good information provided that he had just walked out of the bar and stumbled into the road, and a passing motorist coming around a curve hit him and had no time to evade him, then classically that would be called an accidental death. There was really no intent for that person to harm him. If on the other hand, he had been in a fight and the person that he was in a fight with got in his vehicle and as he was running down the road, barreled over him in an attempt to intentionally harm him, then for purposes of death certification, that death would be classified as a homicide. But if all I know is he's found dead in the road and we don't know exactly the circumstances about how he came to be hit by a vehicle, then I would classify the manner of death.
Denise Sells, I'm wondering if there's going to be an allegation that because it was wet and snowy, he was pushed into the mud, therefore less injuries. That could be something that's brought up. I did not think of that, so fair point. But I guess that's possible. I hadn't thought of that. So, I mean, that is a fair point. Maybe that's what happened and I didn't think about that.
Death is undetermined.
You said that they had the 4 different lacerations on the head. Do you have an opinion other than blunt force trauma of how those were inflicted?
I can't tell you exactly how those were inflicted. There's nothing very specific about a skin tear that allows me to say it was caused by being hit with this or being struck by that. They're relatively nonspecific. Some lacerations are patterned, and I can get some idea. These were not patterned in any way, so I don't know exactly what his head struck or what struck him in the head.
And at the time you did the autopsy, you said you had reviewed the information and you were aware he had been run over by a car, correct?
Yeah, I think the information I had at the time was that there was a vehicle at the scene and that there was apparent blood or some body tissue on parts of the car that suggested to the investigators that he had been struck by the vehicle.
And with those injuries, could they be comparable then to what you would see with somebody being hit by a car?
Yeah, I mean, the typical injuries that we would see in someone that's struck by a car, depending again on how they're struck and at what speeds, are things like abrasions and contusions and lacerations. So the fact that he has some abrasions could be from being, either striking, parts of the vehicle. The types of abrasions he had were more kind of the scratches and scrapes that you might get from the ground or from being under a vehicle and being sort of, dragged or hitting things underneath there. The lacerations are non-specific. They could be from striking parts of the vehicle as well.
Could they also be from being struck by something else?
Yeah, I can't say with certainty what the impacting object was.
So if he was hit with an object before he was hit by the car, you wouldn't be...
Mimi, Denise made a good point that I hadn't thought of, which is the ground was muddy and slippery, so he might have actually just been compressed into the mud. I was just struck by the lack of injuries. While he did have 3 rib fractures, and it seems like from all of the autopsy that he did, the only other injury that he found internally was a cut to his tongue. So that's where I'm having a hard time. But Denise did make the point that it was, the ground was soft, and if he got run over on soft ground, maybe he would have been further depressed into the ground rather than, receiving all of the injuries that we would find kind of consistent. To be fair, Bond, none of the story makes sense, and especially that bit, so...
be able to differentiate that without a pattern?
Not in this case, no.
Are you able to determine if the injuries were inflicted before or after the thermal injuries, the burns?
I can't say with certainty whether they were or not. In some instances with burns, if there's an injury there prior to the thermal injury or the burn, it will also show burn injuries. In this case, since the burns were mostly just on the surface of the skin and there weren't burns down into the depth of the injuries, I can't definitively say that they were there beforehand and therefore that the exposed tissue also burned. But due to the degree of burning, I can't exclude that they were there before.
Typically, do burns of this severity bleed?
Burns in and of themselves don't typically bleed a lot. I mean, it tends to be more sort of, weeping and loss of fluid from, the skin, which kind of keeps us what's in and what's out of us. Once that's broken down, the fluid starts to leak out, but they don't really bleed per se like a laceration or a gunshot or a stab wound would.
In your experience, if someone were on fire, would it be possible for them to run a short distance?
Yeah, I mean, there's nothing about being on fire that would immediately incapacitate you. Never been on fire myself.
That line. My brother was 3 years old when he was accidentally backed over in a driveway in Florida. Luckily, the driveway was sand, so he wasn't significantly injured. I have my favorites. That is so, by the grace of God. Good night, nurse. Yeah, that's definitely a good thing, because sand is good. Everyone should have driveways made of sand.
So I don't know. I've never seen anyone on fire, but I'm pretty sure that you could, and probably would, want to try to get away from the source of fire or get someone. Isn't that what they sort of teach you in school? Or at least they did when I was in school. Don't run around like crazy because you'll just fan the flames and burn more. But you're supposed to, stop what you're doing and roll around on the ground.
Any other significant findings in this report that I have neglected to discuss other than the toxicology?
I don't think so. I mean, I think we've discussed, the injuries that were sustained in my opinion as to why he died.
So I'm going to have you flip to the toxicology page. So the last page, I'm going to have you flip to that one of the toxicology report. Yep. So can you describe for the jury what we're looking at here on the top there of this toxicology page?
I just want to make sure there's 2 pages to the toxicology report, so I just want to make sure I can read which one is up there. Sorry. My vision is
I believe
the urine.
This is the analysis of the urine specimen.
Right. So both a blood and a urine specimen were tested by the toxicology laboratory. In the urine, there were 2 substances that were detected: hydrocodone and hydromorphone. Those are both opioid pain medications.
And are they connected together or are they separate substances?
They're very similar substances. Hydrocodone is a prescription painkiller, opioid pain medication that goes by a lot of different brand names. The pill form is oftentimes marketed as the brand names Vicodin or Norco. Hydromorphone is the major metabolite of hydrocodone. So if you take hydrocodone, your body then breaks it down to some extent, and one of the products that it forms is hydromorphone, which is also a pain medication. Hydromorphone can also be prescribed on its own as a separate pain medication, oftentimes under the brand name Dilaudid. But when I see both of them together, it is most commonly in the setting of someone who has taken hydrocodone and it's been metabolized and hydromorphone is present.
And were you
Good
aware
point, Kiwi Green.
then that in this particular instance that Mr. Stermer had been prescribed some medication for an ear infection?
18 years ago when I authored this report, I don't know if I knew that or not. I don't recall knowing that at the time, but there's been a lot of time that's passed between when I did the report, when I did the autopsy, and now.
You don't get hydros for an ear infection, at least never that I've heard of. Also, they didn't seem to say that they didn't make clear that he had a prescription. Now, that being said, the Midwest and really the entire country and world has a big issue with opioid addiction, but a lot in the Midwest and more rural areas. So, wondering if he was struggling with addiction.
now. So I know I have subsequently been informed that he was prescribed a medication that contains hydrocodone.
Are you familiar with Entex HC?
Yeah, I know it's I think a liquid medication that contains hydrocodone as one of its components.
So when you say a liquid medication,
I think it's something that you would take, like, it's liquid, you pour it out and you take it as a, like with a teaspoon, as opposed to like a tablet solid form.
are you familiar with a drug, I'm not going to pronounce this correctly, Meclizine?
Meclizine?
Meclizine. Are you familiar with meclizine?
I know what it is.
And what is it?
Meclizine is often, I think, sold as under the brand name Antivert. I think it's an antihistamine medication.
So you said Entex could possibly show then as the hydrocodone.
I think Entex has actually got more than one constituent to it. I think it's a liquid that has, as one component, hydrocodone. And so taking Entex could certainly result in the toxicology findings that we see in this case.
How about the meclizine? Would that show on a toxicology report?
With the testing that we currently do, yes, I do think it would. The testing that was done 18 years ago, I'm not sure.
So you would have had to test specifically for like an antihistamine?
Even if we would have tested for antihistamines, not all antihistamines are the same. I believe that the classes of drugs that were detected or that were screened for in the urine are listed on the report, and I don't think that antihistamines are listed. So I don't think it would have been detected.
Meclizine is an antihistamine. It does sound like it's a bad thing, but it is more like, I guess, an antihistamine, something that's going to help you with allergies.
On the toxicology screen of the urine that was.
So you had a standard panel that you tested for?
Yeah, at the time we submitted it to the lab. I don't know, what the name of the specimen or the panel would have been, but there were standard drug panels that were performed on blood and urine. Usually it was a little bit more comprehensive in the blood than it was in the urine. In the urine, based on the listing of drug classes here, antihistamines aren't listed, so I'm pretty certain it wouldn't have been detectable in the urine. Antihistamines were listed in the panel that was performed on the blood. But again, there are a large number of drugs that are listed as antihistamines, and I know some of the antihistamines that would have been detectable, things like diphenhydramine, which is Benadryl, are pretty commonly detected. I don't know if meclizine was listed as one of those that would have been detectable.
And you brought up then blood and urine screens, just in those that you're testifying. Can you explain the difference or what was done here or why it wasn't done here between the blood and the urine screens?
Why the testing was different?
Or can you explain the difference between urine testing and blood testing?
Like why a substance is in one but not in the other, or?
Yes.
Okay. So in this case, the hydrocodone and hydromorphone were detectable in the urine, but they weren't detected in the blood, and that is likely due to one of two reasons. So after a medication is taken, whether you ingest it or you inject it or however you actually take it, it will eventually end up in the bloodstream and will go to the organs and will exert its effects on the various organs. While this is happening, the body is also metabolizing it and getting rid of it, for lack of a better word. One way in which the body gets rid of drugs is to excrete them into the urine. And so it's not uncommon for us to do testing and see a substance both in the blood and in the urine. It's still present in the blood, it's being metabolized and excreted in the urine. After a while, most of it has been removed from the blood, but it's still present, being excreted by the kidneys into the urine. So in a case like this, it may just have been that he took it long enough in advance of his death that it was no longer detectable in the blood, but was still present in his urine. The fact that a substance isn't detected in a toxicology screen doesn't mean that it's absolutely not there at all. It just means that it's not there at a high enough concentration that the test can actually detect it. So that would be the other possibility as to why it's negative in the blood, but it's positive in the urine. It may have just been at a very low concentration, below the threshold of the testing.
If someone were to take any sort of medications or substance just a few hours before their death, would that be something that would routinely show up then in a toxicology report?
With a lot of caveats, the answer is yes. Most drugs, if you take them orally, have to be absorbed through the stomach or the intestine. So it takes a little while before they show up. Like if you take an aspirin, it doesn't immediately show up in your bloodstream. It takes probably, you know, at least some minutes for it to be absorbed. Yeah, I've lost my train of thought. What was the question again?
Just if somebody were to take something very short, like a small period before
Oh, okay, he can join the Petty Express because we lose our train of thought here even when we are on a train.
their death, would it show up in their blood?
Yeah, usually, as long as it wasn't just a minuscule amount of it. If you took something an hour before your blood was drawn, it would probably show up in the blood. If you took it 24 hours before, depending on, you know, the dosage, how much you took, and whether you were taking it daily up until that point, it may not show up in the blood, but probably show up in the urine. In this case, hydrocodone and hydromorphone have what are called half-lives of a few hours, meaning that, you know, once it's in the blood, it takes a couple of hours for it to be halved, and then another couple of hours for that half to be halved. So it would be present in the blood probably for a few hours, at least after you took it, but it might be present in the urine for hours or maybe even a couple of days after you last took a dose.
And I've put up on the screen then the blood results. And were there any findings in the blood results?
Yeah, the only thing that was detected in the blood was some caffeine. All of the other classes of drugs that were included in the testing panel were not detected.
And at the time in 2007, when you did the autopsy, did you test for THC or marijuana?
It looks like in the blood, cannabinoids, which are what class of drugs marijuana is in, they were included in the blood drug screen, and there were no cannabinoids detected.
And in your experience, do cannabinoids stay into the system longer than a few hours?
Yes, generally, especially if you use marijuana regularly. Again, depending on how much you use, it may be present for hours, days, sometimes even in the urine for many days, if not weeks after you've stopped using it.
At the time in 2007, would you have tested for sleeping medications such as Ambien?
You know, again, since I don't do the testing, I can't tell you other than I don't know if Ambien would have been included in this panel in 2007. My guess is it probably would have been. I know that I've been at Sparrow, I've been at my current employer for 20-some years, and I know that we have seen cases with zolpidem going back many, many years. So I think it probably would have been detected if it was there above the threshold, but I can't say with certainty.
And in this case, there was nothing detected if you would have tested.
Yes.
How about muscle relaxants?
Again, some of the specific muscle relaxants probably would have been detected, but probably not all of them.
I think I failed to ask you, you have as the cause of death the thermal injuries, but how does someone actually die from a thermal injury?
Well, there's lots of different ways. I mean, people that die sort of, you know, contemporaneously with the burn, so they don't survive. Many people survive burns and then die of complications, oftentimes infection and that sort of stuff once you've exposed the skin or the underlying tissues to the external. Many people end up with infections. Acutely, it's thought to be due to shock, probably due to loss of all of that skin surface. There's loss of body fluid, and so it tends to be sort of a shock.
Deborah Thiel, I would think that some lawyers might go into field like medical, fraud, medical and things that would have medical backgrounds, but I would think it would be a subset. And I would think that they have to learn along the way. And welcome, Squid Raiders. Welcome, welcome. If you are just joining us on the Petty Express, we are watching the retrial of Linda Stermer. This is in Michigan. Linda is accused of bludgeoning, setting on fire, and then running over her husband, Todd Stermer. Now, she was convicted in 2010. This incident happened in 2007. And her conviction was overturned in 2018. Now the state has seen fit to go ahead and recharge her. We have already gotten so many gems from this trial. One of her defense attorneys looks like The Rock, only The Rock from Timu. And then her other defense attorney, moves at the speed of molasses. And is Shatner... must be a William Shatner fan. We are currently listening to Dr. Michael Markey. He is the forensic pathologist who, did the autopsy on Todd Stermer. This is still the state that is questioning him. It looks like we get the state for the rest of this time, or possibly something has gone crazy. Oh, no, I remember this. So we have a little break because, you guys, the shenanigans are afoot. The woman who decided to not respond to a subpoena, because why would you, is coming up next. So I think they take a quick break to explain to her what a legal subpoena means. It's going to be all the crazy.
Situation where you lose fluid, you can't keep your blood pressure up, you can't perfuse your tissues like your brain and your heart and all of the organs that you need, and that results in your death. It may also be related to inhalational injuries. If you actually have heat-related injuries to the airways, you may actually develop some respiratory complications of those thermal injuries as well.
Any other significant findings that I failed to address in your report?
I don't think anything of significance.
I have no further questions, Your Honor.
I'm going to
Shenanigans incoming, incoming, incoming.
Some other matters, but remember, the rules: do not discuss the case with anyone, no social media, no research, no investigations. And, okay, well, Ms. Siderby, would you mind? I think that was your exhibit. We'll retrieve the exhibit. Yes, yep. Did I say that right? Am I supposed to? No, he's still going to be here, right? Yeah, we're going to do the longer break now. Okay. Yep, he'll be back. Thank you.
Are those screw holes or bugs?
Yeah.
Okay, you talked to them.
All right, so the jury is not present. This woman was subpoenaed to come in.
Yeah.
Okay, you talked to
I talked to
them?
my messenger. I think it was him. I asked him, I think it was yesterday. I'd have to look at my messenger, but we talked on messenger, and then I looked it up this morning and it said I had a bench warrant.
Okay, you messaged one of them, or?
Yeah.
Okay.
Yeah.
Counsel, since you happen to be here, defense counsel, Mr. Mueller, since you happen to be here, she's indicating she messaged you or Mr.
No,
Kelly?
Art. I think I talked to him on messenger.
Art?
Yeah.
That would be Linda's significant other.
Yeah.
Oh, okay.
So then I called that's when I emailed this morning, and I called and found out, because I seen it online. I looked at
Okay. Okay. Are you on anyone's probation or parole right now?
No.
No? Okay. Anyone wish to be heard?
Are you sure about that, ma'am? You decided to wear your formal tank top into court, and are you going for rose gold or are you going for blonde? Because if you're going for blonde, you need a purple shampoo and you need to get an ash corrector, because I don't know what color this is supposed to be, but I am confused. Also, don't look indignant when you don't, show up for court and then act like it's everyone else's problem. You're giving us blondes a bad name.
Well, first of all, I have a concern about the defendant's significant other communicating with witnesses in this case. He's not a party, he's not an attorney, he's not an investigator. He's a significant other, so that causes me grave concern here, Your Honor.
Well, who contacted whom?
I reached out to them.
How did you find?
I think, go ahead. I think it was me that did it. I don't remember. I'd have to look at my phone and tell you for sure. Because to me, this wasn't really like that big, that significant. I think it was me that reached out to him. I don't remember. I'd have to look.
Do you know them personally, or?
Well, I mean, right, but
Why are you texting Linda's boyfriend to tell her you're not coming to trial? I am beyond confused. Ma'am, you look like you are of a vintage of myself. Are you continuing? Are you going to sit here and tell me that you didn't realize that a subpoena meant get your ass to court? And then you decided that you were, oh, he was contacting witnesses. What the hell is going on here? She might have well water. That is fair.
I heard that the trial
Thank
was
you so
going
much,
on and
Kiwi
stuff.
Green. Be safe.
But
in
I
your
want to know
travels.
how she knows Ms. Stermer's new significant other, because they were neighbors in 2007.
No, when I talked to him plenty of times on Messenger, previous, like, I think it was 2019 and 20, I talked to Linda and our
This lawyer is about ready to suplex her, and he is not a dainty guy.
previously, like a long time ago.
Anyone else?
Just like a friendly, just talking.
No, DK Purple. We've apparently gotten to the part where a witness for the state contacted the boyfriend of Linda Stermer to tell him that she wasn't going to be in court. Do what now? Now the state's all Twitter pated because, you know, either the significant other, the boyfriend, is contacting witnesses, or something is hinky going on here. But I think we're going to need the entire Scooby Gang, because this judge looks like she has not day drunk enough for this crap. She is like, where is my Arbor Mist?
Right?
Yeah, well, we didn't talk too much about the case, but a little bit, like, in general, just like how Linda's well-being was and stuff, how she's doing since she got out.
Okay. How'd you get here today?
The deputy?
Deputy brought you? Okay. Okay, anyone
In handcuffs, I hope. You ignored a subpoena, and then you talked to Chick's boyfriend like she has a part in this.
wish to be heard?
Well, first of all, I'm going to ask the court to prohibit this individual from having any contact with the people's witnesses. He's not an attorney. He's not a private investigator. He should have no reason to speak with anyone. And if he wants to play a lawyer, he can go to law school. If he wants to play private investigator, he can get his license. So this is extremely disturbing and frightening that this individual is having contact with our witnesses. Especially since there's no reports ever being prepared, there's no discovery of any of these conversations being provided. I'm very upset by this, Your Honor, and I'm kind of holding back as much as I can here because this is very frustrating. The other thing is, I think at this point in time, the court needs to arraign on the bench warrant. She was validly served with a subpoena. I'm in agreement that probably a bond should be set in this matter.
Your position?
Yeah, like I say, it's showboating right now, first of all.
Takes one to know one, sir.
Second of all,
Oh, the petty has started. Rumble between the two wrestlers. We have Discount the Rock in this side and Man with No Neck, Singlet McBaldy.
she inquired about Linda Stermer's well-being. They were friends and neighbors for years. There's nothing wrong with that. And in terms of anybody reaching out to anybody, it came from the witness to our side. So there's no issue here.
Ma'am, so what'd you say, you live in Grand Rapids?
I do.
Okay. Is there any way to get her on the stand today?
No, I have experts that have been waiting that I'm not going to be able to get on the stand today. So I'm not going to put her failure to appear on a timely fashion ahead of a priority of somebody who's in a professional career and is now going to have to come back.
Ma'am, stop continue to looking confused. No, that's not Timu the Rock. This is this is Man with No Neck. Timu the Rock was this guy. So that's how I've named them. But she continues to just look confused. Cornfused beyond all doubt as to why subpoenas work. Oh, odd job is, you know what? He does look more like an odd job. Odd job and man with no neck. That's Tim You Big Show. I'm going to need to get publicly buzzed in here so he can explain to me what wrestling means.
He was in a professional career and is now going to have to come back.
You guys, is it bad that I'm thinking of those Geico commercials, so easy a caveman could do it? Because with the underbite and the bigger jaw or brow bone that she has, I mean, we are seeing a fabulous bit of her cleavage, but she's still Lady Neanderthal. I'm throwing it out there.
Your Honor, I would also inquire if she has reliable transportation.
I don't. No.
And I can say for the record, Your Honor, I wasn't paying attention, frankly, when she was talking about reaching out to somebody. I don't know when that happened. I contacted Ms. Calhoun a week and a half ago. She hadn't been served. I just wanted to know, have you been served? Are you going to come? So I have to subpoena you. And do you remember what you said in your affidavit? Because I'm going to ask you questions about it. So that's the only and I don't know if she's confusing Mr. Bean with me, but that's my contact.
Ms. Calhoun, do you have any controlled substances in your system now?
No, I don't. No.
Survey says, I'm going to go ahead and put more faith on the women I see in Maury who are there for the 18th time to figure out who their baby daddy is. So, ma'am, I'm going to guess you have something in your systematicalness.
Amphetamine by chance?
No.
Okay, what I'm going to do is I am going to set this matter for a status conference for Tuesday. Say 1 o'clock. Do you think you can get her on the stand?
I could try to make adjustments so that she could be on the stand.
Okay. I'll set the matter for Tuesday at 1 o'clock for a status conference. And ma'am, due to your failure to appear here, I am concerned at this time about non-appearance when I hear about the transportation issues as well, so I am going to set a bond.
Okay. I have, my brother lives in Lawrence. I can live or stay in Lawrence.
Okay.
That's okay.
Well, for now, I'm going to set bond. I'm going to make it $1,000 cash or surety.
Oh my gosh.
Okay. To make sure that you show for the year on time for your, under your subpoena.
Miss, the rest of us functional human beings and those who cosplay as one, you know, we manage to get things done without being, oh my gosh, you know, what am I supposed to do? How is it I'm expected to come to court, you know, by my own self? No, Wilma, you go to jail. You go to jail and you don't pass go. And could you fix your necklace? Because it's bothering the hell out of me. And if you're going to have huge boobs, could you wear a shirt that lifts them and separates?
Sounds like both sides were inquiring about using you and you didn't show.
It wasn't because I was unaware that I was needed, right? I mean, like, honestly, I've had some stuff going on in my life that I didn't even, like, my own.
Hey, miss. Hey, sweetheart. Come here, sweetie. Just come over to the bosom of Mama Mo. Now, it's not like yours, but, you know, we'll get... But, most of us have shit going on all the time and we still manage to show up for court. Do you think I wanted to go to jury duty? Not particularly, although I did make a video out of it, so I did monetize it, so there you go. But do you think many of us want to go to court? No, the answer is no. It's called life. It's called everyone has shit going on and don't have time to deal with it. No ridiculousness. But you are testing the very last scintilla of Jesus in my soul. Why? I mean, ma'am, are you a millennial? Because this makes sense if you're like 24, but that looks like 37 hard damn years put away wet road hard, okay? So don't you be talking to me about a fellow sister in the, school of hard knocks that you couldn't get some stuff done. Because I managed to get all of my ish together this morning when I didn't really feel like it. It's called life. It's called being an adult and putting up your big girl panties. I don't know. How about you just stay in jail so we know that you'll be here when you're needed? Because it seems like you got so much stuff going on that you can't keep track of where you're supposed to be. So maybe, just maybe, court will, or, jail will help you.
Problems. Okay. Not that this isn't a big problem, but my own issues, like serious issues. And I wouldn't just miss something because I didn't want to be disrespectful or just because I was being disrespectful to the court. I had no idea. Like,
Believe me. Believe.
Was for April 7th, because that's when we anticipate starting. So it wasn't like she missed our subpoena.
She missed yours. Okay. I am setting a bond, but the reason it's not too high, ma'am, is because we were able to get you here, but we had to get someone to get you here.
I don't have a car.
Okay. We'll have to figure out a way for transport then, okay?
No.
If you post that bond. Okay. Okay.
Fair over somebody else's problems.
It's your problem. You are a goddamn adult. Shut the hell up. Take the crime. Take the thing. Are you insane? All you have to do is pay $100 to a bail bonds person. You decided not to show your happy ass up. This is why I can't work with the public, because I am cool with toddlers and my young ferals being discombobulated and, needing correction sometimes. What I can't deal with is a 40-year-old toddler. Great success. This woman decided not to show up for her subpoena. Then she decided, in lieu of telling the court that she didn't have reliable transportation, she could reach out to Linda Stermer's boyfriend, who is sort of quasi working with the legal team from what the defense or what the state is kind of insinuating. But basically, she didn't show up to court, and the judge is like, okay, I'm going to put a bond out because, you're saying you have unreliable transportation. You need to be here. We have had, to bounce or to bump back experts that actually have, real jobs and have to go back to that. And this woman has decided, in defense of her not showing up because whatever the hell reason, well, she's got stuff going on in her life. Do we not understand? She has stuff and big stuff. Now, I am sure that none of us suffer from big dramatical stuff going on in our life every fucking day, but we manage to continue. So let's continue with Discount Backwater Dixie Trailer Park, Meryl Streep.
Okay.
I have real problems.
Ma'am, I'm going to have you tested at the jail, okay? Anything else, anyone?
And they're going to drug test her at the jail. What do you bet that's not going to pop up clean? Now, I mean, as a person who's failed many a pregnancy test, I can tell you she's probably going to pop up hot on something.
Ma'am, if you do post that bond, okay, if you're able to post the bond either directly or through other people, you need to report back here on April 1st at 1 o'clock, okay?
I don't have a car.
Okay.
And
Well,
thank
make
you
sure
for
you're
the
in
super
contact
chat.
with the lawyers.
Has anyone told Wilma that tears don't work on fire, bitch? No, they haven't. Again, this is the female privilege. Well, it comes up positive. And I am not trying to make fun of her because she does seem like she is on something, but I am so daggone ridiculously tired of, I have stress, don't you understand? Like, ma'am, I understand your stress, but I still got bills to pay, so what do you want me to do about it? Put on your big girl panties like the rest of us and get on with life, because shit is going to happen whether you're sitting there having a pity party for yourself or getting up and doing the damn thing. So you can choose to sit there and have a pity party, and I have done the same thing. I have thrown myself a pity parade, but, I had to make a choice as to whether I was going to sit in that parade and waller as this woman did, or if I'm going to get my big girl panties on, get up with my day, and not let, my diagnosis dictate my life. So I'm sorry, ma'am, but I just do not give two rats' asses. In fact, I could physically care less, but I don't think they have quantitative, measurements for that.
So that they can contact you. If you don't post it, they'll contact you at the jail, okay?
It's not fair.
Okay.
Life isn't
Okay,
fair.
thank you. Anything else, anyone, on that matter?
You did order testing in the jail.
Yeah, I ordered that. I have her tested at the jail.
Are we addressing the issue of this art person speaking with witnesses, Your Honor?
I don't know who he is. Is he here?
He's here in the courtroom. I've seen
Okay.
him every day.
Where is he?
I believe it's the gentleman back there in the blue shirt, Your Honor.
Sir, yeah, are you having any contact with witnesses in this case?
Back some time ago, I contacted her to find out an address on her and a telephone number, but obviously that changed because Wolf had it on a subpoena for her, and they wasn't able to, and she messaged me yesterday and said that.
Now, sir, I also don't have a law degree, but I also don't dress up in a three-piece suit and pretend to be one. And I do think that is what Timu Big Show is pissed off about. You have neither the technical knowledge nor the finesse or practicality to be either a private investigator or part of her legal team. Why are you reaching out to any witness? This is so conked. And sir, I get it. Look, I have legal pads too. But just because I have a legal pad doesn't mean I'm a lawyer. I mean, I have a fountain pen too. That doesn't mean I'm a fountain. I mean, he does give me a good idea, because now I'm just going to wear blazers and everyone's going to think I'm a lawyer. I'm going to start wearing my blazers again, y'all. I too can pretend to be a lawyer.
She found out the cops were looking for her, and I said, yeah, because they issued a bench warrant for you.
Okay.
That's the extent of our conversation.
Sir, I'm directing from now going forward, no contact with witnesses, okay? Is he part of the defense team, or is he a boyfriend of Ms. Stermer or significant
He's
other?
been helping our defense team with legal issues.
Okay, I don't see, is he a significant other of Ms. Stermer?
Pardon me?
Is he a significant other
Yes.
of Ms. Stermer?
Yes.
Okay. I'm going to order that he have no contact
No
with
problem.
witnesses due to the commingling there of roles. So to keep it clean, no contact with witnesses, sir.
So
You
I
understand?
did bring it up with Mr. Kelly yesterday. I informed him that she contacted me.
Okay,
And I told him not to contact her.
okay.
Yeah, I mean, so we've already took care of that, but I did inform.
I can't change what the past, but going forward, zero contact, okay? Thank
I
you.
didn't reach out to her just
Okay.
in the beginning for a phone
Okay.
number.
Okay. Anything else, anyone?
Just, we want to make sure it's on all.
Okay, so JKD Buck, what the state is alleging is that fake lawyer Esquire over here is doing legally stuff for the defense team. Now, I have not ever heard of the guardian ad boyfriend or the guardian ad lover, but apparently her boyfriend was doing some different things for the defense team and reached out to one of the witnesses to get her current name or her current address and phone number. Now, said witness got a subpoena but decided not to show up, so FaceTimed this wiener-looking guy with the binder, who is the boyfriend. Neither the state, neither the defense, or even the courthouse. She FaceTimed this guy to see why she had a bench warrant. Now, the state is righteously mad that, this hanger-on, this pretend-a-cop, this whoever he is commingling in the defense's case. Now, discount, oh gosh, who did we say he looked like? Not The Rock. Basically, the defense wrestling lawyer completely stated that this was innocent and things like that. Timu Oddjob from the defense said, well, he's helping us out with things, this is all above board. And you can tell that Discount Big Show from the state hates this defense like with a passion of 1,000 suns. If we don't see a rear naked chokehold, I'm going to be very upset, mostly because I want to say rear naked chokehold, although I don't even know what it is. To be fair, I haven't watched wrestling, but I can only imagine with those singlet things. Do you take off the singlet for a rear naked chokehold? Because I could watch wrestling more. Inquiring minds want to know.
All witnesses.
Yes.
Because obviously he had her contact information. He's spoken to her in the past. It's not just her. We're asking on all witnesses that he does not contact any of them. Thank you.
Okay. Anything else, anyone?
No, Your Honor.
Okay, thank you.
Well, I mean, I did confess that I have failed many a pregnancy test. Surprise hearing. It's a
That underlying
surprise.
data is gone forever, best of your knowledge.
To reach your community,
Interesting. So they started this, looks like, hearing without going back on the camera. So we will have this. Stop with the music. But it looks like they started the hearing.
Would have had the chromatograms. There would have been a continuity from Mr. Shinsky. There would have been a return postal card showing the number and the address going to Mr. Shinsky when we returned the samples. There would have been any notes would have been on the chromatograms. Near as I can recall, that covers most of it.
Okay. So essentially, if I could boil it down, it'd be kind of like a lot of
Now, I believe that the defense is trying to do a Dalbert hearing on the expert the state has in the gas chromatography, I think, or mass spectrometry that they did on the testing of both, I think, Linda and Todd's clothing to look for presence of accelerants. No, this woman looks like Hatchet Face. I mean, I put it on the tag. She looks like Hatchet Face with that hairdo to me. Look, y'all, I tried it. I tried to do a little bit of a bump it with a headband just for her. Yeah, I'm not a mass spectralist.
we have some information that's related to chain of custody of the evidence. Is that correct?
That's correct.
And then we have the chromatograms, which are essentially just the printouts from the machine. Is that right?
Yes,
But those printouts actually require your interpretation. Is that correct?
that is correct.
And you had to review those in order then to memorialize them in your report.
Yes,
And the findings of those chromatograms are in fact memorialized in the report that you have been provided and you have reviewed. Is that correct?
that is correct, yes.
Okay. All right. Just a moment here. I have no further
Okay, I
questions.
can't do this music, so we're gonna have to go ahead.
That underlying data is gone forever, best of your knowledge.
The file that I had asked for at the laboratory no longer exists.
Thank you.
Okay. Brief arguments, counsel?
Now, I will state that both the judge and the state have been incredibly disgruntled, or at least showing disgruntlement at the fact that I believe within the past 3 weeks or a month before this trial, the defense has been filing a flurry of motions. Now, both the judge and the state, especially Discount Big Show, have been incredibly frustrated with the late sort of motion commotion, because there have been years and years to file something.
Your Honor, this isn't even a close call. MRE 703 specifically states the facts and data in the particular case which an expert bases an opinion or inference shall be in evidence. The use of the word shall indicates a mandatory imperative directive, and that's Burton versus Reed City Hospital Corp. 471 Mich. 745 at 752. That's a 2005 Supreme Court case. The other case that talks about it, it necessarily follows that an expert witness may not base his or her testimony on facts that are not in evidence. People versus Unger, 278 Mishap, 210 at 248. That's a 2008 Court of Appeals case. We do not have the evidence. He has to have that to interpret to get to those conclusions of a positive gas test. And why do we require that in MRE 703? Because, as the Supreme Court stated in People versus Kowalski, 492 Mich. 106 at 121 in 2012, expert testimony without a credible foundation of scientific data, principles, and methodologies is unreliable and thus unhelpful to the trier of fact. Not even a close call. People versus Fackelman stated that an expert's opinion must be based exclusively on evidence that has been introduced into evidence.
Thank you. Mr. Blair?
The issue with every case that opposing counsel decided is those are all analyzed within the concept of the confrontation clause. The confrontation clause requires that a testifying scientist that prepared the report be present in court to testify. Obviously, he's here. He did the entire process, so the confrontation clause is not what's issued here. What it seems to me in reading that, first of all, it's facts or data, not facts and data. They're mutually exclusive with one another. So the facts are present here in court today. He's here to testify. The jury, I think, should be able to, Mr. Mueller can cross-examine him about the lack of the chromatograms. I don't think it renders his opinion and findings unreliable. He can question.
703 is really clear. Your witness seems to be testifying as credibly as he can. It's not his fault that evidence got destroyed, but his opinion was based on these two different manners of whatever you call them, but we don't have those. I mean, how are you getting around 703 here?
Because it's memorialized in a report.
That's the conclusion. The report is his conclusion. And so we're looking for the data supporting his report, which normally we would have, but by, a very
By no fault of
unfortunate,
anybody.
no one's fault,
I understand that, Your Honor. I still think it goes to weight, not admissibility. He is a qualifying scientist. He is able to testify about the procedures that was used, what he did, and the results. But I think it goes to weight, not admissibility. I think it's admissible. I think he should be allowed to testify in his report. The jury can give whatever weight it wants. Mr. Mueller can cross-examine him ad nauseum about the fact that those chromatograms are missing and he can't do his own independent comparisons of the chromatograms and so on and so forth. But at least the report should still come into evidence. I think it's a valid record of everything that was done, and he can at least admit the report, and the jury can give it whatever weight they want.
Okay, MLS, how much more does this man have to pay for a tie that's extra long to go around his necular region? Because, I mean, this is a sash I have, but, I mean, he'd probably basically have to put it around my shoulders, and then I don't know how the hell you tie a tie, but, I mean, this is, I'm guessing, the general circumference of his neck. Such a bitch, I'm going straight to hell. That being said, his wife knows where all her sashes went.
To decide who belongs to it at this point in time. If they want to give it no weight because the chromatograms are not here, fine. But they can give it whatever weight they feel or they deem is appropriate. The foundation of him being an expert is not in question. The methodology he used is not.
The irony of this, Midwestern fluffy man talking about weight so much. I don't know why that struck me as funny. I just thought I'd put it out there. As a semi-fluffy that's deflating slowly, I have a pass still. Tanya, she looks like a long-haired chihuahua that was just denied her half of Satan's dynasty. Well, what I was going to say is that she looked like she murdered a bunch of troll dolls. Linda, it's called deep conditioner. Get you some, sit under a hair dryer, get a warm towel, sit on it, let it sit on your hair for 20 minutes, and then for the love of God, use a toner. Get some purple shampoo and conditioner.
In question, and his findings are still present. And I think that's important. And he can testify about the process that was used and how those chromatograms would be reviewed in arriving at his conduct, at his final results. Just because those chromatograms aren't here doesn't mean that those results should not be available.
Where do you see that in 703? Because I'm reading the opposite, that his opinion is based, he said, on two different things, neither of which we have. And the evidence in the particular case, or facts or data of a particular case must be in evidence.
Facts or data?
Facts or data.
Facts. We got the facts. He's testifying as a fact witness. He is testifying to facts.
So he's not going to give.
Is this man arguing with Judge, Auntie Joe? Because, I don't know, she reminds me of an auntie, not a grandma, not a mommy. She's not Judge Mommy, and she's not Judge Granny. She's Judge your sassy aunt. So, but I will say that the two lawyers who look like semi-pro wrestlers hate each other. Now, I don't know if one of them said the other one didn't have a good lift day or one didn't spot the other for some squats, but they carry a passion of a burning hatred of 1,000 suns for each other.
Give his opinion about it?
No, that's in his report. What I'm saying is he's giving facts about what he observed and facts that he saw. It says facts or data.
Because I don't understand that. He said again, I'm not a scientist, but he said his conclusion is based upon these graphs that he does, and he doesn't have the graphs.
I understand that, Your Honor. That's been beaten down here ad nauseum. I completely understand these graphs are missing. If I had them, boy, I'd really like to have them and save us all this 11th hour challenge to our evidence again in the middle of.
And then MLS, if you're still hanging around, John Corman has a question. Have you ever gone before this judge, Dave? Now, I don't know that Dave does a lot of Kalamazoo cases, but I would do all Kalamazoo cases because I think it's hilarious. Although Kalamazoo would be spelt differently on every single paper. Yeah, I know, Tiffany Cox. They aren't using as great of a sound system as far for not being in the presence of the jury. And I was wrong. It's Van Buren County, not Kalamazoo. I just wanted to say Kalamazoo. It's a fun word. Everyone should say it.
Of a trial. So, the problem with this issue is, Your Honor, there aren't really any specific cases that directly address what's going on here. Mm-hmm. This is kind of a novel issue. I did research last night. I think I at least supplied law to the court at 9:30 last night, of which the defense has supplied none. At 9:30 last night, basically trying to find something that would support this. I can't find anything. Because chromatograms apparently are something that no one cares about when an expert's rendering an opinion. And so I think that maybe is somewhat telling about this issue, is that it's not necessarily it goes to the weight, not the admissibility. It's not necessarily the underlying data. That doesn't necessarily supply the entirety of the underlying data, I should say, that the court needs to render a decision.
Okay, well, first off, I don't believe that this is a confrontation issue. I don't believe a machine makes testimonial statements, so we don't have to go there. But try as I may, after listening to the testimony today, I can't get around 703, which leaves the court without discretion. And the court is obliged to, and I quote, "An expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. The facts or data must be in evidence or, in the court's discretion, be admitted in evidence later." He's identified 2 sets of, whether you want to call them facts or data, that he's put into evidence, or that he reviewed, that form the basis for his opinion. Through no fault of anybody here, the company destroyed that data, so we don't have it, which leaves the defense without the opportunity, apparently according to the rule of evidence here, to effectively cross-examine. I don't know that, there's nothing in the rule that leads me to believe that this is in fact an issue of weight. Witness has been very clear. That's what he interpreted, that's what he had, but we don't have it here today. So I'm going to exclude the evidence.
Now, I will say that this is going to be incredibly difficult on the state's case. Now, unless they can find another expert that will talk about the fact that, what the state basically alleges is that Linda Stermer's clothing had accelerants on it, or particulates that showed up as some sort of accelerant from the clothing she was wearing when Todd came out of the house, and she was leaning over him. But what the state is trying to say is that she had the accelerants that, on her. It is absolutely, so this case for the state, and especially without this expert, is going to be incredibly difficult now, because now you have lost the person who was going to interpret what you stated in your opening statement was definitive proof that there were accelerants on Linda's clothing. Now, I don't know, I believe that the defense also did testing on Linda's clothing that showed no accelerant on it. So it's definitely going to be interesting to see how the state is going to pivot, considering this is probably one of their big witnesses. Experts.
May I suggest one other avenue, Your Honor?
Okay.
Could we admit the record as a business record, just not have him testify to the interpretations and his findings? I believe it would be a document kept in the regular course of business at Barker Analytical Laboratories. It could come in as a business record. However, he's not allowed to give us any expert testimony about what he did. He can simply admit the record. Jury can give it whatever way they decide.
Your Honor, that's absurd. He's the expert who's going to testify that the gasoline was positive on the red towels. To try to back.
No, the pit bull crying lady was the witness. So she was Matthew Methilhenney, his girlfriend at the time of this incident in 2007, they were together, and she is actually the one that made the 911 call that we've heard several times during the trial. Now, apparently she was served by both the defense and the state. Now, she said she didn't get the state's subpoena when the defense had reached out to her, but basically she did not show up for her subpoena. There was a bench warrant put out, and she is being held on $1,000 bonds. Yeah, no, not Biff. The one that wore his work, formal thermal, and it was like a maroonish color. It looked like a t-shirt. He was the one who wore his formal t-shirt to, So this has already been a case in which, we don't have a lot of circumstantial or physical evidence. The state losing this, I wonder what they're going to do to pivot, because again, it did kind of hinge on Linda planned all of this because she was in an affair, wanted to, get rid of old Todd to move someone else in. Hopefully not Wiener Guy, although I guess if she's not cheated on Wiener Guy the entire time, maybe she's not a super duper cheater. She just cheated on Todd.
Backdoor this in where he's not even allowed to testify, but you can read to this document to the jury. Come on. We've supplied. I'm not even belabor the point. Thank you.
I do like that this judge is.
Mr. Blair, that would require some research. I'm not going to go on the fly on that right now, but.
Well, then I'm going to ask the court to at least enter an order that Mr. Valliott's not to be referenced by the defense in the closing argument, in any arguments or the red towels or anything along those lines should not be mentioned by the defense.
I'm sorry, these were red towels. These were red towels collected around the house. Now, the defense has stated that these towels were used to bleed the heating furnace. Apparently, it was an oil furnace. I am not sure. I am not an HVACologist, so I don't know what bleeding an oil fuel furnace HVAC system looks like. But what the defense had said was that those towels were used to collect the heating oil that might have spilled out from the valves or...
Because I've heard comment earlier about how if we don't present certain evidence, it's going to be, and I quote, rammed down our throat. So I don't necessarily want that, this to be brought up. I think that's fair and appropriate given how this has played out.
Okay.
Have you tried? One party gets up and makes promises to the jury in opening statement.
I think it's fair to say,
Absolutely.
to comment on what wasn't done in a case, but if he says it wasn't done, that's one thing, because that would open the door to, that's dishonest, because it was done, but just
Well,
let the jury
comes
see
up in
it.
a closing argument. And the problem is we made no promises about what the jury was going to hear from Mr. Belliet.
Right.
So it seems only fair given how this has played out in court. There's a fundamental fairness issue here as well, that it seems to be falling on its face.
Really, Mr. Blair? Because you keep presenting this as this last-minute issue. This is your evidence. You're the proponent of the evidence. If you go back and look at the transcript of this matter in 2021, we discussed...
Someone got Auntie Mom mad.
It's a bold strategy, Cotton. Let's see if it pays off for him.
Well, they just done, when you're a kid and you done screwed up, but you just want to belabor the point, and then mom has to kind of reach back and do one of those things like Caesar Milan. This judge is having none of the state's shenanigans. Like, you guys were the sole arbiters of this, evidence. It was your job to keep it all going. You've had since, 2010. Oh, she doesn't have the big ring on though today, so she might not concuss him.
all of this. And I said, assuming the prosecutor can lay the foundation, I'll allow it in. So you've been on notice, I've been on notice, we're all on notice. It's a rule of evidence. It's a standard rule we have to follow. That's my ruling. So I don't know where this is about fundamental fairness. If the it happens in every criminal case.
The state's like, fairness didn't work for the redheaded chick, but let's try it. Your Honor, you don't understand what stuff is going on in my life. I have to borrow my wife's, dress ties in order to make ties. They have to butcher 3 shirts to get me a neck, shirt. Sir, come on now.
So the defense highlights what evidence you didn't hear. And so if they want to say you didn't hear any evidence of the towels, that's fine. Now, obviously, if they go on and say the prosecution never had them tested or something like that, that would be completely inappropriate. But to highlight for a jury evidence that they don't hear in a case happens all the time.
Well, essentially, if they get up there and say, you didn't hear from the testimony of Craig Balliet, well, you've excluded it, so it leaves us in a kind of an unattainable position. I guess that's where I'm kind of going with this.
Well, I guess what we could do is when we get to that part, you can provide me in advance of what you intend to say to the jury, and we can go from there, if it's as it relates to Balliet.
Each other's playbooks out.
Okay, well then I could just order that you not bring it up. I mean, that's what you'd rather.
If that's the alternative, we'll make an outline, Your Honor.
That's all I'm asking.
Yeah, no, I get
You're not commenting on a witness that wasn't allowed to testify
Right, okay.
by court order.
No, I get that.
I mean, that only seems fair.
That would be fair if it's because he couldn't lay the foundation for the exhibit
Well,
and the opinion.
Let's worry about the closing arguments later.
Thank you.
Okay.
And Ms. Balliet, if I was a little chippy with you, apologize.
Anything else then, counsel, before we?
I do have one issue, Your Honor. So if the defense brings up any testimony that Ms. Stermer smelt or had Mr. Todd Stermer was down there bleeding this furnace, which is obviously not the fuel oil that was found on those towels, it could come in as impeachment evidence.
No, I mean, I think there may come a point where impeachment evidence could come in.
Yeah,
I mean,
so
I have to hear it.
if defense presents witnesses that are going to
someone-
say
yeah.
that she was down, that Todd was down there bleeding the furnace, and if defense starts then putting the fact that there was this fuel oil that was on this rags and she was down doing laundry, I certainly think that at that point we need to revisit this for impeachment evidence, and then we would ask to admit it under a business record, as I've already brought in Mr. Valiak from out of town. So I just want to put everybody on notice. I mean, you can't then go ahead and start arguing after the court's excluded it that that's what happened when we have obvious knowledge that that's not what occurred.
Defense, just be on notice that you may open the door to this coming in as impeachment.
All right, but I want this for the record. There can be no opinion for any purpose that he hasn't laid the foundation to say what he did. To try to get some record in under the business record exception for impeachment purposes where there's no evidence of what he did, how he got there, is absolutely, it's inconsistent with the rules. That's not what that's for. You have to lay the foundation for any expert opinion.
Right now, we're here on the 703 issue. I've ruled on that, and so we'll have to just play other things out as we go.
Thank you.
I just want to make the court aware that we would intend to admit it under impeachment evidence then.
Okay.
Thank you.
Anything else, counsel, before we bring in the jury?
But I only have one question, Judge. If she's talking about, when you talking about impeachment, like bringing Mr. Valiak back in on the witness stand?
I don't know if I'm addressing him or you, Your Honor. We would have to address that path. If they're going to put witnesses up on the stand, or Ms. Stermer's going to take the stand and says, I smelled fuel oil and I washed it and Mr. Todd Stermer was working on the furnace the night before, then I think we have the opportunity, the door has been opened, where then we would be able to then cross-examine and bring that in as impeachment evidence and say, isn't it true that that tested positive for gasoline and not fuel oil? That's all I'm saying. I'm going to be asking for Mr. Valiak to be released on subpoena. So I don't intend to bring him back unless the court were to direct me or order me to bring him back if we need him for that impeachment evidence.
How about if we get there, someone get me some law on whether the evidence that's been excluded under 703 can then be brought in for impeachment? I don't know. I haven't done that.
The only way they would try to do that is to backdoor it in through Jim Shinsky, who then they're going to read question and answer about his interview relating to that. All of this stuff now, given his opinion, as I put in my objections to their exhibits, is irrelevant.
Linda is out on bond or I guess bail, or she has an ankle monitor. So however they do that she has been out and I guess on house arrest or very closely monitored. But she has been out since 2018. And I think that the state very swiftly wanted to retry her. So unfortunately, Swift is, 2025.
The red towels are irrelevant. His CV is irrelevant. His appearance is irrelevant. The red towels have nothing to do with this case, given that you can't connect it to gasoline.
I'm not here to rule on the red towels right now. I'm here to rule on the 703, which I've done, so.
That's the opinion about the red towels.
They might have some reason to introduce the red towels, I don't know.
Give me a second here to clean up.
And then,
So may I let Mr. Valiak
Yes.
off of the subpoena and make you leave then?
Yes.
Okay.
Okay, so the state lost one of their expert witnesses. All right, let's get back to...
Still under oath. Thank you.
All right. So now this is going to be the defense asking questions of the medical examiner. Now, I will say that Discount, Odd Job does a really good job, but he does come off very snarky and a bit aggressive rather dickish, if you will. So, do wonder if he is going to carry that. Linda is the defendant's name. Yes. So, Average Deb, this is actually a retrial. Linda was convicted of her husband's murder in 2010 after filing a habeas, a habeas appeal. Her conviction was overturned due to lack of, effective assistance of counsel, and I think lack of retention of an expert. I've got the decision. I'm going to be reading it or looking at it for a video, and I will get up exactly why she was given a retrial. But yes, Linda is the defendant. She has been out between the, overturning of the conviction and this subsequent retrial. And that is the defendant.
Mr. Mueller?
Thank you. Good afternoon, Dr. Markey. Afternoon. You and I have never met, but we've talked a couple times on the phone, right?
Yes.
And I think we even did a Zoom at one point. Remember that during COVID?
Yes.
I'm going to ask you a lot of questions today about your autopsy report and the results, okay?
Okay.
I want to just first begin with, if I can, something I made a note of. You said when the body came to you, it comes in a sealed body bag, right?
Typically they do. I don't recall if this one was or not. I'd have to look at my report.
But the reason it's sealed, you said, it's important that it's sealed, right?
I mean, generally they're sealed so that when I open the body bag, I know that there's nothing that has happened to the body since it was put in the bag until it was opened.
Right. Important for chain of custody issues, isn't that right?
Generally, that would be the reason.
Okay, because as a forensic scientist, as a forensic pathologist, you're in court and you have to establish a clear record of this was the body at the scene and the evidence with it, right?
Yes, I mean, that's essentially the reason, as I stated before.
And then when it gets to you, you open the bag and we can make sure that what was at point A is at point B.
That would be the reasoning, yes.
That's why you document what's at point B when it gets to you. Am I right?
That is correct.
All right.
I know that's what I thought when I first looked at him. I even picked up, because I was like, is that, did we hire the doctor from Scrubs? I mean, is this what happened here? Because, y'all, I just can't. He's the actor from Scrubs. I didn't know that he was actually a court witness, too. That being said, that man is smexy.
Do you know typically if the medical examiner's office has a policy, like where you work, you do things for autopsies for different counties, don't you?
That is correct.
Where the MA's office has procedures and policies where evidence can't be removed from the body unless the medical examiner's office signs off on it.
Yes, in the counties where I serve as the medical examiner, the body is my jurisdiction, and anything that's on the body is my jurisdiction at the scene. And if something needs to be removed for some reason at the scene, then generally it is done at my office's authority.
And you would have a paper trail because you don't want critical evidence disappearing later on, fair?
I'm not sure. I mean, it would be documented in our report if there was something at the scene that was removed that was thought to be significant.
Okay. You don't have any record of anything being removed at this point, in this case?
I wasn't the medical examiner in this case, so I'm not responsible for that. I was just asked to do an autopsy and give an opinion to the Van Buren County Medical Examiner's Office.
Okay, so let's talk about these opinions. I want to talk about, obviously, the data you had included there was a fire and Mr. Todd Stermer was severely burned and ultimately perished. Fair?
Yes. I mean, I'm sure it was more detailed than that, but that was 18 years ago. I don't recall all of the details.
Then the next piece of data you had was there was some evidence that he had been run over by a car. Yes. Specifically a van?
Yes.
Did you know it was a Ford Econoline van from 1993?
I don't recall knowing the specifics.
All right. And the body then gets to you, and you talked about the thermal injuries, and we'll talk about that in a minute, but I want to focus right now on what you call the blunt force trauma injuries. And I want to go to your report, if we may. Can you see that?
Yes.
And you have your report in front of you, right?
Yes.
First thing you had was lacerations, you said, right?
Yes.
All right. Those lacerations were to the top and the side of the head, correct?
To the top, to each side of the head, and one to the back of the head.
If I say BFT, blunt force trauma, fair?
Sure.
So when we have 4 lacerations, right?
Yes. Yeah, that's what.
The Petty Express is the place to have dark humor. And you know what? I didn't think boil a bag, but that was pretty good. Minute rice.
The report indicates.
One to the top, right?
Correct.
One on each side of the head, on the ears, you said?
They were on the side. One was on the left side of the head, above the level of the ear. The other was on the right side of the head, above the level of the ear.
One's on the right, one on the right side. And where was the last one, on the back of the head?
Yes.
So I put those down correctly?
I can't see
Oh,
it.
counsel's in the way.
Yes.
All right. Then we had, I think, linear abrasions, right?
Yes.
And you described those skin burns, you know, like you fell on the pavement.
I think I specifically stated that they were like scratches or scrapes on the skin.
Okay. And 3, we had rib fractures, right?
There are rib fractures, yes. 3 rib fractures.
2 on the left side.
Correct.
They were ribs 3 and 4.
Correct.
1 on the right side,
That is correct.
and that's rib 4.
It was rib 3.
3. Okay. Those were the only blunt force trauma injuries you saw, right?
No, as is listed in my report, there letter C, there were lacerations on the right shoulder and upper back, left
Forgot
upper
that.
arm, and lateral left back / chest.
Okay.
I have
So,
not been a fan of
lacerations.
his style.
To the back and chest? Or just the back?
To the back,
Chest.
to the left upper arm, and to the lateral left chest or back. It was on the side of his torso, depending on what you wanted to call it. It was either his lateral chest or his lateral back.
Okay. Now, those lacerations to the head, you said, those 4 were, I believe and it's in your report, I believe it's called minimally depressed?
No, the minimally depressed injuries were fractures of the skull. The lacerations of the skin were just splits.
No,
in the
I
skin.
apologize. They missed skull fractures we missed, right?
Yes.
All right. Those 2 skull fractures were minimally depressed, right?
Yes, that means they were sort of,
So when he's talking about the lacerations, basically they're on the front upper chest, mubular shoulder region, going back around the back, upper shoulder deltoids, and, your upper back also included to the torso. So Tiffany Knock, the state is alleging that Linda Stermer attacked and bludgeoned her husband around the head, got him incapacitated some way, lit him on fire with gasoline, and then when he got out of the house, she ran him over. Now, there is, there is a dent on the Econoliner van. There is viscera and body fluid that is consistent with Todd's, and even on the undercarriage. So I don't know how we're going to square this circle. Now, I will say that I was shocked with the lack of, really big, internal injuries if he was alleged to have been run over by a fairly big van. But one of the chatters reminded me that it was snowy, rainy, and kind of yucky outside. So this was on, ground, it wasn't paved. It wasn't even, graveled over. So this is soft earth. And perhaps he was just pushed down more into the earth than actually receiving as many, deep internal injuries. Now, this is the defense that has him on the stand right now, and they are going over all of the injuries that Todd had.
I don't even think I called them fractures per se, because they weren't like full breaks through the bone. It was just the outer surface of the bone was inwardly dented, for lack of a better word.
I've been told by other doctors, medical examiners, a depressed skull fracture can be described as if you took your finger through some icing on a cake a little bit. That'd be about right?
I mean, it's basically it's just a dent.
Right.
It's an invagination of the surface.
Those skull fractures certainly were not life-threatening, were they?
Those fractures in and of themselves, no.
Okay. Those 4 lacerations, and by the way, those skull fractures you say didn't penetrate the skull, and we didn't have any brain damage, did we?
No, there was no obvious injury to the brain.
Okay. In terms of other organs, there was no obvious injury to the heart. You would have noted that.
No, there's no heart injury.
There are no obvious injuries to the internal organs of the gut, liver, spleen, kidneys, nothing.
That is correct.
Okay. So we don't have organ injuries. In terms of fractures, you described these 2 minor fractures. We don't have any other fractures, do we?
There's fractures of the skull and then fractures of the ribs.
We'll talk, the ribs, you said at least the ones on the left for sure are consistent with what you find when people are doing CPR.
Yes, they could be due to CPR.
Okay. And even you said it's uncommon, the one on the right, but you can't rule out that it could have been done by CPR. Fair?
That would have been very unlikely that a posterior rib fracture would be from CPR.
Let's say the one that wasn't done by CPR was caused by impact with the vehicle. That's not life-threatening, is it?
No, that fracture in and of itself would not have been life-threatening.
Defense, where are you going with this? Like, no, I mean, it mangled him a bit, but if anything, we should get her with assault, with with a vehicle. Where are you going with this, defense? Because I'm thinking between the fire and being run over by a car, you're probably not long for this earth. But, I mean, defense, you seem to think you know what you're doing, so let's continue.
The lacerations to the back and the upper left arm, those weren't life-threatening, were they?
Unlikely. I mean, lacerations, especially of the scalp, and they can bleed. So if they're not attended to, they could bleed enough that you could lose blood, and it could be significant. But of themselves, they're not usually, immediately or significantly morbid.
Okay. I'm going to go look at these lacerations because I was told you took autopsy pictures, didn't you?
Yes.
All right.
I didn't. They were taken at my direction by an assistant during the autopsy.
Okay.
They did do a tox screen, and it came back that he had both the drug and the metabolites of hydrocodone. Now, he was diagnosed with an ear infection and given some sort of liquid medication that also had hydrocodone in there. Now, as far as what I know about any of this, thus far they haven't alluded to any poisonings, but I mean, she did just about every other thing if you believe she did it. Now, if you are starting to be swayed by the defense's side, well, things happen.
Give me a second. I'm going to show you a few autopsy pictures. that have already been labeled as Exhibit H in ours. They're coming from your autopsy. You do take pictures of standard part of autopsies, right?
Yes, during autopsies, we take general photographs of the body and then photographs of anything that we think is significant.
I'm going to describe them right now.
Okay, you're not going to show them though?
I'm going to show him if he says he took pictures.
Okay, I just want to make sure, and then, make sure you don't show them.
Your Honor, our foundation needs to be laid. He said he did not take pictures. So I think the foundation needs to be laid that these are in fact pictures taken or...
I'm going to show him, if you don't mind. I'm going to approach. You've seen pictures of the autopsy?
Yes.
H1 is the head.
Yes, that is a picture of the head that was taken during my autopsy.
Yeah. H2 picture, what does that describe?
Yeah, those are the abrasions on one of the arms.
Yeah. H3 shows some what?
I think it's specifically meant to show the lacerations on the left upper arm and the lateral left chest.
Taken during your autopsy?
Yes.
And 4?
That's a picture of the back of the decedent, and you can actually see the laceration on the right upper back of the shoulder area.
Taken at your autopsy?
Yes.
Your Honor, I move for the admission of Exhibit H1 to 4, 1.1 to 4.
Your Honor, we don't have copies of these. I'm not really sure what he's admitting. I mean, I'm sure I have the copies of the autopsy, but I don't know what he's admitting. Is he admitting this as digital to the jury? Is he admitting these as copies to the jury? I'd like a copy of what he's admitting.
Your Honor, they were Dropboxed my exhibits 3 weeks ago.
What are you admitting to the jury?
The 4 pictures of the autopsy.
Are you making hard copies of them?
I have an extra set right here, but I've Dropboxed them to them.
Let's let the prosecutor see them.
If they're part of his Dropbox, I've seen them. I just didn't have them here to see which ones he's admitting. So
your plan is to provide a hard copy.
All I'm imagining is the doctor from Scrubs looking at them like they're all a little latent French. You know, the R word. He just looks like, you guys are all dumb.
Copy for the jury?
No, it's yes, as the jury exhibit.
The jury?
Yes.
Okay, so it sounds like he's laid the foundation. They're a very accurate representation of the autopsy photos.
Thank you.
Yes, they are some of the autopsy.
Counsel, are these? Yes, sir?
No, unfortunately it doesn't on this apple here, so I try to blow it up on the big screen.
Can I, Counsel, can you approach it so we can talk about the nature of the photos?
He's like, God, give me the strength to get me through this trial.
You now, you may find them disturbing. They're autopsy photographs, so the defense attorney, I've alerted to him to get him on and off.
Well, so this is extremely interesting. I want you guys to pay attention because the state has already gone and the state apparently didn't introduce any autopsy photos. This is interesting. Why wouldn't, usually the state has no problem introducing autopsy photos. Now, I do understand that this is an incredibly graphic case. I mean, this man had burns over 90% of his body, but I have never seen the state not want to put in autopsy photos. Now that I'm saying that, I think a Wisconsin trial, I think the Darrell Brooks case, they just had them do the sort of anatomical, man with the sort of, the kind of labeling on that kind of pictogram guy where everything are. And I'm telling you, it's not him, but I think we need to put an APB out for this man because someone is impersonating you and playing a medical examiner. Maybe she didn't have the horses.
Off the screen as quickly as possible to prove whatever he's trying.
And that woman who is leaving the courtroom is Todd Stermer's mother. Obviously, I doubt as a mom you want to see these photos, and then to know that, you know, your son was also a burn victim. You know, she might not have seen pictures.
Trying to show you right now, but and then in the jury room, I'll make sure that they go inside an envelope so that you can choose to open the envelope or not when you're in that room to see them, okay? So they are admitted. What are they? What?
H.1-4.
H.1-4 is admitted, hard copy.
Thank you. I'm going to show you H.1 from your autopsy. Is that a photograph, sir, of the 2 lacerations to the top of the head that you saw?
Yes, that's a laceration of 2 of the 4, or that's 2 of the 4 lacerations on his head.
Okay. And those didn't go below through the skull or anything?
They went through the full thickness of his scalp, essentially, pretty much down to bone. And 2 of them, the one on the left of that photograph, it had the indented small fracture underneath it. The other laceration was that had the skull fracture underneath it, was not visible in that photograph.
H.2, what does that depict?
I believe that's a picture of one of his arms, and it shows obviously that most of the skin surface is absent, and sort of the exposed skin is often red, and then there are some of those linear abrasions, scratches, scrapes there on his arm.
3, what does 3 depict for us, sir?
Yeah, this is a photograph that's depicting the lacerations there on his left upper arm, and the sort of abrasion with a smaller laceration there on the left side of his chest up there near his armpit.
And 4, sir, what does 4 show us?
This is a photograph of his back. Again, he's got diffuse burns, and then what you've highlighted there is the larger laceration that's on the back, his upper back, shoulder region.
Okay, thank you. So, as we went through all those injuries, in sum total, if you assume the van made those?
It very well may have. I don't know exactly what made every single injury, but the constellation of those injuries, lacerations on several parts of the bodies and skin scrapes, could certainly be due to being struck, especially if you went underneath the van and hit various.
Yes, Tiff Knox, he did. I mean, he had 90% of his body burnt. I think that the doctor said that, you know, while they aren't sure the exact mechanisms of a fire death, be it, you know, shock or the body not being able to maintain blood pressure, fluid loss, when you are that burnt there, your body just cannot handle it a lot of times.
Objects that are on the undersurface of the van and on the ground.
Okay. I'm going to show you, before I publish it, I'm going to show you from Macioski's Exhibit 1, E.1 to 3. Those again have been provided to counsel. They're your detective's pictures.
Your Honor, and I mean this with all respect, I think the process is the issue here. Normally, when you admit exhibits, you admit hard copies for the witness and then publish to the jury. We just don't get them on an iPad. And the only concern being to ensure that these same exhibits that are being admitted here in court are the ones that are being provided to the jury. And I have no doubt Mr. Mueller would not do anything like that, but I just want to make sure that we're following the right procedure here with the admission of exhibits.
Get your TPS report in correctly, or Office Space, and you have to tell the Bobs. You don't want to explain to the Bobs what it is you'd say you do here. So, you know, if you don't want to jump to conclusions, you better make sure those TPS reports and the standard operating procedures are done and taken care of, or Tim You Big Show is going to have something to say about it.
Going forward, I'll let you do what you will here, but going forward, I agree with Mr. Blair that it's a cleaner record if we, whatever it actually is that you're gonna move to admit, if it's a hard copy, we do it as hard copy.
It will be admitted as a hard copy, but I could conditionally admit it with, to link it up under Rule 104 with Detective Maciowski since they're his photos.
Well, I said I'll allow it this time, but going forward, further examination and exhibits, get us the hard copies, please.
Thank you. If I may have just approached the witness quick. Doctor, I'm going to show you about 3 photographs of the van that was involved in this incident. You see photos of the injury or the blood to the front bumper, or the what's called the brush guard.
Yeah, I can see some red material. I can't tell what it is, but could be blood. Yep, it looks like, again, similar material on the undercarriage.
Right.
Yep.
Okay. So we show Maciowski picture 004, that's the van.
Your Honor, I don't think we've admitted these under a proper foundation yet. They're being published to a jury. They haven't been admitted. These are not his photos. I'm not even sure what foundation we've laid here.
Your Honor, under Rule 104, I can conditionally, I'll link it up and you can conditionally admit the exhibit because it's their detective exhibit.
Well, you shouldn't be showing it to the jury if it's not an admitted exhibit yet, so.
It can be conditionally admitted, subject to linking it up.
It hasn't been admitted, Your Honor.
In any event,
Mr. Mueller, let me roll on this. I'll have you wait and admit it when you can lay a proper foundation.
I'll be happy to do it with Detective Maciowski. You've seen those photographs, sir?
I just now have, yes.
Those injuries that you saw to Mr. Stermer are consistent with having been run over and striking.
Did someone put Audacity on clearance? Because no, the hell you did not just say in any case to the damn judge. Sir, I have often thought that I wouldn't do well in a legal professional career, but mostly because my face is contempt of court. That being said, I would never, like, y'all, I would still be in a coma if I had talked to my mom the way this man just talked to the judge. And if I were the judge and you had talked to me the same way this man had, I hope you have your checkbook out, because contempt of court means mama's got purse money.
Various undercarriage components, isn't it?
I mean, the injuries themselves, as I've stated before, very well it could be due to being struck and overrun and striking things on the undercarriage of a motor vehicle.
Right. So the fact of the matter is, any of these blunt force trauma injuries that we had that we listed were not life-threatening. They didn't kill Todd Stermer, did they?
That was not my opinion, no.
Ooh, what are we writing on the, pad of awesomeness?
Van impact, all those blunt force trauma did not cause death, correct?
Yes, that was my opinion. My opinion was that he died as a result of the burns and the inhalation of products of combustion during the fire.
Your Honor, I guess I'm not understanding why we're writing everything from the doctor's report on a tablet. My fear is that we already have the exhibit from the doctor's report. Now writing it can be misconstrued. It's not an exhibit. I'm not really sure why we're rewriting the doctor's conclusions or statements on a tablet.
Your Honor, I can examine and summarize his opinion. He agrees with this. This is simply presenting his opinion in a summary form as we're going.
grant the prosecution's request on this one. The witness can testify and the jury can hear his testimony. It doesn't need to be written down by the counsel.
Okay. Then let's talk about, sir.
The tablet. Thank you.
The judge is going to pull this trial around and ain't nobody getting Frosties. It's just like two kids in the back seat. I'm not touching you. Children, do not test the last single scintilla of Jesus that your
Second
mother
thing,
has left.
the burn injuries you talked about, you and I have talked before, right?
Yes.
And the burn injuries, you have told me, and you tell me if I'm summarizing this correctly, the burn injuries, you can't say, I know an accelerant was used based on these burn injuries, fair?
Yeah, that's out of my area of expertise to say exactly what type of.
Kathy, Michelle, I'm not quite sure because I have seen tablets like that used before as demonstrables. So I don't know if this is a ticky-tacky thing, if this is more the judge's comfort with having a tablet used. I have seen them used to sort of illustrate a point or create a timeline for other cases. So I don't think that they are blanket disallowed, but it could be for the comfort of the judge. It could just be her ruling. This is the time where I wish I was at least a paralegal.
Burns they're thermal burns. They may be flash or flame burns. I can't tell.
Okay. Third thing, let's talk about now the toxicology report. You discussed a little bit about the results of the urine test and the blood test, right?
Yes, I think we went through
the
the toxicology results.
Okay, let me talk about that.
Yeah, Deb, I don't quite get, well, if she bludgeoned him, he didn't die, and if she lit him on fire, he did die, but the van didn't kill him. I don't know where the defense is going with this. I know the defense's stance has always been that this was a tragic accident, but none of this follows anything.
I'm going to show you what the toxicology report, which is part of the exhibit they showed you. And the urine specimen.
I don't believe so. I believe that he passed shortly after everyone got to the scene and they put him into the inflatable or land boat to move him away from the fuel tank. I believe he maybe lasted 10 to 15 minutes after the fire.
Discussed hydrocodone, morphone. Those are the metabolites, right?
Hydrocodone is a primary drug. Hydromorphone is a metabolite of hydrocodone that can also be administered as a drug on its own as well.
The blood test, let's talk about the effects of things in the blood test.
Okay.
You see that?
Yes.
Okay. The only thing it had was caffeine, correct?
That is correct. The blood screen was only positive for caffeine.
And when you have tests that have screens in the blood, that's what you have is basically the active ingredient, right?
Well, when it's present in the blood, we know that it's circulating and it's likely having effects on the body. If it's only in the urine and it's no longer circulating, then it may not be having its intended effects on the body.
Okay. It's out, if we talk about it, it's in your system versus out of your system. You heard that before, right?
Yes.
He didn't have any of this hydrocodone or hydromorphone in his system, otherwise it would have been detected in the blood test, fair?
As I stated previously, there were no detectable levels. That doesn't mean, as I stated previously, that it wasn't possibly there at a lower concentration than what the testing screen is able to detect. So a negative result is essentially it's not there in a concentration that the test can detect.
And the test can detect concentrations that would have an effect on the body, can't it?
Generally, yes, that it's set low enough that if it is present below that level, it would be considered, essentially not significant.
Yvonne, they haven't gotten to that yet. That might be something that the defense brings in. The state is pretty set on Linda bought gasoline. And if their expert witness had been able to go in and testify, there were red towels that were found around the property, around the home, that appeared to have the chemical marker for gasoline and not the heating fluid from the furnace on them. So she went to a gas station earlier. The defense has pointed out that she went to the gas station on the day of this fire. And the state, if they had been able to get this evidence in, or at least the expert in, then the expert would have testified that the accelerant on those towels was gasoline. Tanya, Godspeed.
You also talked about Entex HC, right? Remember that this morning?
Yes.
That's cold medicine, prescription cold medicine.
I'm not familiar with exactly why it's used.
Okay. But it has hydrocodone in it, right?
Yes, it does.
And you said typically it's by a liquid syrup.
I believe, yes, it's usually given in a liquid form.
Okay. So any of this hydrocodone, as far as your professional opinion, would not have been in a system to have any effect on Todd Stermer, fair?
Right. There was none detectable in his blood, so therefore likely he was not experiencing the...
I still question why he was given hydrocodone cold medication for an ear infection. Now, he could have had an accompanying, or upper respiratory infection. That would make sense. But for the ear infection, as the chief complaint that he apparently was complaining about, I don't see, hydrocodone liquid medicine being given.
The effects of hydrocodone at the time of his death.
So if somebody, witness or the prosecutor, suggested that he had been drugged, that would be inconsistent with your objective evidence, wouldn't it?
It would be consistent with him being dosed hydrocodone sometime before he died.
In other words, therapeutic levels of hydrocodone, which would be just taking cough medicine, right?
There's no levels on there, so you can't say it's a therapeutic versus a non-therapeutic.
I think he was testifying as to the time distance between the two, not whether it was therapeutic or not.
I guess I'm not clear on the question.
You heard of the phrase therapeutic levels?
Yes.
All right, what does that mean to you?
They're generally levels that if you measure them are what you would expect to see or what's expected to be seen if the drug is in a concentration that is deemed to be effective from a clinical standpoint. So if you're talking about pain, what levels of medications cause or result in control of that pain? And that means in a sample, does the number that we're given for a certain drug fall within that range? Let's say the therapeutic range is 4 to 10. If a drug is present at a concentration of 6, then it would be considered to be within the therapeutic range and be in the range that is expected to exert its effect to treat whatever condition you're treating.
Bottom line, if he was taking cough syrup prescribed by his family doctor 2 days before, that cough syrup containing hydrocodone was out of his system by the time of this fire. Isn't
Your
that
Honor,
isn't
he
that
has no
true?
knowledge of what he took. If he wants to ask this as a hypothetical, that would be more proper than just testifying himself as to what the defendant did or did not do.
I hate it when exes fight with each other. This man has more audacity. I mean, can I say himdacity? Because I don't like women acting like buttholes, and I don't like men acting like buttholes. Now, granted, I do manage to dog more on the women because they usually have those annoying HR, voices that bother the ever-living snot out of me. But, sir, himdacity has not been on sale. You are denied. Stop with the audacity, okay? I don't know which lawyer school you went to. Maybe this is how he just lawyers. I don't know. I can tell you that as a juror, it would really rub me the wrong way.
And then asking him to agree.
Your Honor, it is a hypothetical.
And there are no levels on the toxicology.
It is a hypothetical.
I'll let you rephrase it then, or state it again as a hypothetical.
Doctor, hypothetically, if Todd Stermer had taken...
All right, douche canoe. That was sufficiently petty enough for you to get a Petty Express membership, at least a pass aboard the Petty Express. Not VIP yet. You still need to, keep your douche canoe levels to an absolute minimum, or you will be kicked off the Petty Express. I doubt you will be able to stay with us for very long. So God bless you while you're still here on the Petty Express, sir.
taken cough medicine that was prescribed by his doctor 2 days before, Entex HC, for cold and ear infection, whatever effect that drug had was out of his system by the time of the fire.
Yes, in this hypothetical situation, if he took the drug 2 days before, it would be consistent with it not being detectable in his blood any longer, and he would not be experiencing the effects of that drug at the time of his death.
Or at any time before, because he didn't have it at detectable levels in his blood. Isn't that true?
Well, I'm not sure what you mean by at any time. I mean, if he
Yeah.
had taken the drug 2 days before.
Basically the question he should be asking him is, on average, how long does this stay, in your system? I think you have incredibly hit the point that whether he took the cold medicine or didn't take the cold medicine for an ear infection, it was not affecting him during the time of the incident. I think you have gotten that out. I think that if for whatever reason that's what you are trying to do with that, that's fine. I think belaboring the point is ridiculous. I don't understand it. And he's wording it in a way, again, I don't understand why we are bringing and shining a light on this so much.
And 5 minutes later, he probably was experiencing the effects of the drug.
My question was poor. I'll try to rephrase it. If at the time of
Okay, you admitted a fault.
the fire, he didn't have this hydrocodone in his system, you with me?
Yep.
Then no matter when he took it, whenever, it was out of his system.
Right, I think it's fair to say that, given the apparent brief time period between the fire and his death, that his concentration of those drugs would have been similar to what we see when he died, and probably was not under the effects of the drugs at that time.
Just going back to the idea of these lacerations on a blunt force trauma, you had 4 lacerations in 4 different places, right?
Are we speaking of just the head?
Yes.
Yes, there were four separate lacerations on his head.
So if there was a suggestion that maybe Todd Stermer got hit by a frying pan, that wouldn't be consistent with the injuries you saw.
Sir, I don't know that I'd want to throw out that hypothetical, considering your client looks like the mom, oh God, Anne Ramsey from Don't Throw Mama from the Train. I mean, because she looks liable to take some cast iron to some people, okay? So maybe I wouldn't be throwing this out there as a hypothetical, but you do you, boo. And are you wearing shoulder pads, sir? Are you effing kidding me?
Given that you know he had contact with the undercarriage of the vehicle. Isn't that true?
Well, again, that's, I guess, a multi part question. To answer your first question,
Spinster, I think that some of the things the state has said or claimed to, I guess what I will say is that the state hasn't shown me a lot of evidence to conclusively point to Linda being the progenitor of all of these injuries on Todd. Now, that being said, we're only on day 2 of the trial, and we've already had an expert witness thrown out, and one witness who decided not to show up for a subpoena. So at this point, I don't know if Michigan has rules or what's going on. Now, the frying pan has not been admitted into evidence. So I don't know, you guys. I don't know why we're on a frying pan, Medea, Diary of a Mad Black Woman, why we're going on with this, but sure, why not frying pan?
I can't rule out that he wasn't struck with something based on just the lacerations. He wasn't struck one time with something, but clearly there are impacts to his head, and I can't tell you exactly what caused those impacts. Given the fact that it was reported to me that he was run over by a vehicle and there was evidence of body fluid on the undercarriage of the vehicle, it seems quite reasonable that that would be an explanation for the injuries that were seen on his head.
As you like to say, within a reasonable degree of medical certainty, it's more likely than not that all of those injuries to his head...
Objection, Your Honor, that's not what he said. It's mischaracterizing the evidence.
She can clean it up if she'd like.
No, I think that I'll sustain that objection.
Your opinion is it's more likely than not, given the evidence
The same question, Your Honor. Objection for the same grounds.
I'll sustain the objection. I don't think he's given that as his opinion.
Do you have an opinion, whether it's more consistent, given the data you have, that he suffered those head lacerations from impact with the undercarriage of the vehicle?
I think I've answered the question that I don't know exactly what caused each of the lacerations. They are explainable by injuries sustained from the undercarriage of the vehicle. Can I exclude that there wasn't an injury from something else prior or in association with it? There's nothing specific about them that allows me to say definitively what caused them.
Based on the evidence you encountered and addressed in 2007, right?
My opinion is that based on my interpretation of the injuries, they are caused by blunt impact. They could be from the undercarriage of the vehicle, and they very well may be, but I can't say definitively what caused each separate injury.
Okay. Now, part of your process when you're doing forensic examinations, you're familiar with the scientific method?
Yes.
Scientific method is you collect all the data you can relevant to your topic, right?
Yes, as part of what I do, I collect data.
Okay, now listen to me and we'll see if we can work through this step by step. You collect data.
Oh, hell no. No, this man, look, I would not be able to control my face with this man. It is, in fact, probably great that we are not married to each other because I don't want to live in Michigan. It's even colder than here, and I live in the butthole state of Indiana, so I'm not moving up north. That being said, oh, hell no, are you going to break this down and talk to me like I'm a 4-year-old when I am a damn doctor? Tammy, no, I'm trying to do my stupid physical therapy, but it really hurts, and you wouldn't think that this would be such stupid physical therapy, but basically what I have to do several times a day is do internal and external rotation for my hip, and oddly enough, my internal rotation is, well, basically both of my legs have very low hip mobility, so I'm trying to do that, and unfortunately, all of my physical therapy hurts. So I was trying to do it, you know, inconspicuously, but it is not comfortable when I do it. But I do have to do them in order to keep my mobility. So that's what you were seeing.
Right?
Yes, we've established that.
As much data as you can that might be relevant.
Okay, let me
Yep.
count these out for you.
Then
sir.
you analyze that data, right?
I interpret the data.
And
Then you
no.
develop hypotheses, which are really just working theories of what it could be.
I mean, that's the scientific data. I do.
This new Miss Frizzle in the Magic School Bus sucks. It's science, it's science. Oh, everyone, it's science.
Do an examination, I interpret it based on my training and my experience, and come up with what I believe is the most accurate conclusion.
Okay? You test
Yeah,
your
accurate.
theory against the evidence that you have, right?
Well, in my line of work, I try not to come up with a theory and then make
Ouch.
the data fit my theories. I take the data and I interpret it based on my knowledge of pathology, forensic pathology, and the circumstances in which the death has occurred.
Okay. You understand the scientific method is to develop, when you test your theory, to try to disprove your theory, to rule out something.
Yeah, I understand that the scientific theory. I'm telling you what my protocol is in determining cause and manner of death.
And your protocol in determining cause and manner of death involves what you folks call in the medical field differential diagnosis, right?
Well, yeah, a differential diagnosis is when you take a finding and you come up with a list of possibilities that may explain that finding. For example, I don't treat patients, but if you come to the hospital with abdominal pain, they will take a history and they will say, well, we think your abdominal pain may be due to this, this series of potential diagnoses, and we will do further analysis.
Bond, James, this new Miss Frizzle has to go.
to try to shorten that differential diagnosis, hopefully to a definitive diagnosis.
Right. So you're taking, it might be 3 or 4 things, and you're taking tests to try to rule out something, and ultimately you have a diagnosis. But you have to consider what it could be, right?
Right. I mean, when I look at an injury on the body, I have to evaluate an injury independently and determine whether it's a blunt force injury like a laceration or a stab wound or a gunshot wound or something else. That's part of what I do in not just saying there's an injury here, but then analyzing the injury based on my experience and my training to determine what that injury actually is.
Like a simple one. If this was suggested that Todd...
Okay, why are we doing this? Why are we doing this? I don't understand what we're trying to dig into here. Yes, the pathologist is going to attribute these blunt force trauma things to a car run over because that is the evidence he was given. Now, it's not him jumping to a conclusion, but it is him working within the fact pattern that he has, which is there was blood and viscera found both on the front bumper and the undercarriage of the car. He might be trying to mess up the jury, but he doesn't understand what he's talking about. There is a reason that I think, who used to be an engineer? Was it Alan Jackson who used to be an engineer? And that's why in the Karen Reed case, he did all of the, canon daddy. There is something to be said about if you are going to have medically specific questions, you should have a lawyer that understands medical, medical information. Because no matter how many times you take this doctor through the, Hippocratic method, the Socratic method, and the scientific method, he is still going to say the same thing. He is still going to say, I can't, definitively say what went on. I can tell you that his injuries happened in a close proximity to death. and, you know, that kind of thing. But he is not going to be able to definitively say, yes, she done runned him over. No, she hit him with a frying pan. No, unless there were distinct tool marks, then, and markings, like if you hit someone with a, I don't know, one of those wrenches with the bobby thing on the bottom so you can make it bigger or littler. And if you beam someone on the head with that and they have the indent of the circle thing, then yes, you can include that particular weapon and exclude a baseball bat. But he's not going to be able to do the CSI bullshit. Ugh.
Stermer died of a gunshot wound. Your examination of the body finds no gunshot wounds, right?
That is correct.
So you could rule out gunshot wound, correct?
That is correct.
That is part of how you do the differential diagnosis. And now forget gunshot wound, we'll focus on something else, right?
Right.
Okay. So,
Look, there might be a legitimate reason Mr. Moe doesn't let me play with his tools, mostly because we don't communicate what he needs out of his toolbox, because he says weird things like needle nose pliers and a plumber's wrench. And I'm like, so is that the one that has the little thin like tweezer things? And then he's like, yes. And I was like, and the plumber's screwdriver, would that be the one with the little bit that you can make it bigger or smaller? It's just a lack of communication. If you just said the bit, I would understand what you meant. Of course, generally, he needs them in a quick, fast hurry, and me asking all those questions may be a little annoying when he's, holding up a piece of drywall and I'm asking him what a thingamabob is.
in terms of his thermal injuries, these burns to the skin obviously would be painful, right?
Yes, I've never experienced burns like that, but I have burned myself and it hurts.
It hurts.
Captain
And the pain
Obvious.
is immediate, isn't it?
Yes.
Where are you going with this?
Now let's talk about your manner of death and what you've considered. Am I right that when you're talking about manner of death, there are several different categories?
Yes, there are 5 categories in the state of Michigan that you can put on a death certificate for manner of death.
Would one be accidental?
Yes.
Would one be suicide?
Yes.
Would one be natural? You had a heart attack?
Yes.
Would one be homicide?
Yes.
And one would be undetermined?
Yes.
And if it's undetermined, the only one that supports a crime is homicide, correct?
I'm not sure that that is a correct statement.
Wait a minute. Are we going with the death certificate said undetermined, not homicide, therefore my client was not guilty? Because, I mean, this sounds like a legal argument that I would make, and I am a twice college dropout. That being said, I don't have law school, student loans, so, on balance, am I really that dumb? That being said, where are we going with this? This is hurting my soul.
For death certification purposes, it's not for use in this setting. When I put something on a death certificate, it is for death certification purposes, for public health, for statistical purposes. For example, most automobile crashes we classify on the death certificate as accident. There's no intent generally to cause harm, and yet I've sat on a stand like this multiple times on cases where I've called a death an accident, but someone has been charged with a crime, say driving under the influence or reckless driving. So just because I call something an accident or it's...
It seems like one of those things that a lawyer would know and kind of understand the reasoning behind, but, A for effort, D for denied, and F for FU, Mr. Lawyer.
not legally binding in the sense of the judicial process. Likewise, just because I call something a homicide doesn't necessarily mean that, from a legal sense, a crime has been committed.
Sir?
Yes. I'm trying to answer your question, which is only one of them indicates a criminal activity.
Can you answer my question, yes or no, if you're able to?
You didn't ask him to answer yes or no. How the hell? Sir, did you take your Midol today? Do you need a Snickers? 'Cause you're acting kind of like a bitch. So do you need a Snickers? I can tell you when I am hangry, I end up, acting a little cahoonty. So perhaps take, a little break, get you a granola bar or something, or a protein shake, or a chicken breast and raw eggs, whatever it is that floats your boat for your macronutrients. But could you stop being an insufferable asshat for like 5 seconds, just at all?
Restate the question.
That's badgering the witness. He asked for an answer. The doctor gave him an answer. It was directly in response to his question.
She can follow.
He is badgering the witness.
That's hardly badgering the
I'll
witness.
sustain the objection.
Sir,
Do you feel badgered?
you make these categorical classifications based on the evidence you have at the time, am I right?
Yes, based on the autopsy findings and the circumstances in which the death occurred, I provide an opinion as to what I believe is the manner of death.
Okay. And in this case, your manner of death was undetermined, isn't that fair?
That is correct. That's what is stated on my report.
If you had evidence at that time that it was a homicide, you would have listed it as a homicide, correct?
If I had had...
Oh my God, please say no shit, Sherlock. Look, he has been giving out douche energy. I'm not a fan of being a douche without cause, but he has been giving out asshat energy. So I fully, as the conductress of the Petty Express, our sailor of sarcasm from the planet of Sarcasium. Yes, Sailor Mo of the planet Sarcasia says that you may answer this in as dickish a form as you would like. So yeah, the manner of death would be, accidental, natural causes, self-deletion, homicide. The mechanism of death would be, at least for Mr. Stermer, it was thermal injuries. So that would have been the mechanism of death, and the manner of death he ruled as, oh gosh, undecided, or I know it's not undecided, undetermined.
Had enough evidence that I felt independently comfortable that his death was due directly to someone else's intentional actions, then yes, I would have called it a homicide.
Okay. So let me just kind of summarize and make sure we're clear before I leave you. The van impact had no connection with the death. The death was caused.
That's not what he said. Oh, sir.
By thermal burn injuries, fair?
Yes, I believe his death was caused by the thermal injuries.
You're not qualified, and you can't say that an accelerant, gasoline or anything else, had a connection to his burn injuries, fair?
Right, I don't do accelerant testing. That's out of the realm of what I do.
There were no drugs that were detected that were in his system at the time of his death, fair?
That is correct.
And finally, the manner of death is undetermined, fair?
That was my opinion at the time, yes.
Give me 1 second, Your Honor.
Well, he's no Ben Shapiro, or even Robbie Shapiro. Hell, even Kato Kalin. Or the guy that gave us the Kardashians. Ugh.
I know you're a busy man, Doctor. I don't have any other questions for you. Thanks.
Yep.
Thank you, Your Honor. Doctor, you don't need to know anything about the specifics of the van to do your report or your examination, do you?
No, not to actually do the autopsy. I mean, when asked questions to try to correlate injuries, then yes, it's sometimes useful to know, but to determine that those are blunt force injuries, I don't need to know any specifics about a vehicle.
It was enough information to know it was a van.
Yes.
And I just want to be clear on your findings. Those rib fractures could be from CPR, correct?
Definitely the two left-sided anterior rib fractures. Very well it could be from...
And for those of you who don't know, anterior is going to be in front, so posterior is in the back. So on his left side, so you will see it on your right. I don't think I have my camera mirrored, but there were several from rib 3 and 4 were broken on the anterior side. Now on the right side, there was a posterior break on the third rib. So the doctor contends that the anterior or front breaks could and are consistent with giving CPR. Now the posterior break is not.
CPR. As I've stated before, the posterior rib fracture would be unlikely to be due to CPR.
But even the other ones could not be from CPR.
That is correct too. I can't tell you that the ones on the left.
Do you know where the injuries are from? I feel like I am in Mahogany. Do you know where you're going to? No, neither of these lawyers have any idea where they're going to. Yes, the man can't tell you how and when these happened. We can be Schrodinger's, pathologist for years and years, and this man will still never be able to tell you exactly what happened. Other than, yes, the thermal burns were the cause of death. Could we stop with the hypotheticalness? I'm just done.
Left side in the front, they could be from something else. They're just, they could be explained by CPR.
That is a question. Now, I will tell you that their injuries can be acute in that they have happened directly before the death. So, if I happen to pass away falling down the stairs and, breaking my ribs and, concussing myself to death, they could tell that they were probably an acute injury or an injury right at the time of death. But subacute injuries, he didn't label them as subacute. In fact, he said that they were acute, which meant that they were probably happening either contemporaneously to the being run over or at least very close to death. So he wouldn't be able to, timeline out when these injuries happened in a series of like a timeline. He could just tell that they hadn't even started, repairing himself. There was no evidence of healing.
Or they could be explained possibly by the van.
Yep.
And the injuries, the 4 separate lacerations on the head could be from the van.
Yes.
They could be from another blunt force trauma.
Right, if he had been struck with something else prior to being run over, then one or more of them could be from being struck. I can't say with absolute certainty that...
They could be from a frying pan.
Potentially.
It would be consistent with the injury, right?
Yeah, there's nothing specific about the injury that would allow me to say that he was or wasn't struck with something.
And I just want to be clear, you did the autopsy on January 8th. The fire was January 7th, so you're talking one day after, correct?
Yes.
And so you based your information and your report on the information you had the day after the fire?
Well, the final report wasn't issued until at some point later, so there probably was some more information that was obtained. But everything all the information is summarized in my report as to what I had at the time that the report was issued.
And that's what you used then to come to your conclusions?
Yes.
And I just want to touch base, you talked about the pain that would be, that somebody would have from those burns. Would touching then also cause additional pain to the patient that's burned that badly?
I would assume so. I'm not an expert on pain, but it would be painful.
He works with dead people. How does he know how the living feel? To be fair, if I had to go to doctorology, I would probably go into pathology as well.
Greg asked him to speculate. He's not qualified.
He's a medical doctor.
Now he's talking about I would assume.
How long will that?
So based on you saying that it would be painful for somebody to touch those.
And Welcome, Baker Raiders. If you guys are just joining us, we are finishing up day 2 of the Linda Stermer, Michigan versus Linda Stermer retrial. This has been a ish show. Now, Linda Stermer, the woman who looks, well, you know, like Dolores Umbridge and the woman from Anne Ramsey had a baby, is accused of bludgeoning, setting on fire, and running over her husband. Now, the state just got one of their expert witnesses removed, and we are now with the expert or medical examiner. Now, the medical examiner has been asked just about ad nauseum the dumbest questions that one has ever answered or asked. Like most pathologists, he can't explain what exactly happened, to this gentleman, but he did pass away from thermal burns. Now, the state is in recross, and she's just cleaning up a little bit. The state and the defense hate each other with the passion of 1,000 suns, so let's see how this continues to go. Also, just for those of you who are coming in, this case takes place in Michigan. So after the state finishes their recross, or their recross, or their redirect, sorry, then the jury will be allowed to ask questions. So it will be interesting to see where the jury's head is after we've had the medical examiner. I will state that I was shocked at the lack of traumatic injuries, considering they claim that Mr. Stermer was run over. He had 4 lacerations to a small degree, one with a small depression fracture that did not go through the bone on his head, and those were to the top, both sides above the ear, so kind of corresponding laterally, and then to the back. Now, he also had 3 broken ribs, 2 on the left side on rib 3 and 4, and then 1 on the right side towards the back on rib number 3. Now, the doctor did say that at least the 2, rib fractures on the left side could be, consistent with CPR, but the back one is not. So the one on the right side with the posterior break was not. They have been trying to get this man to tell them, exactly what happened. The van was parked in their backyard. So she was driving from the front yard to the backyard where they have a walkout basement, I guess, in order to A, pick him up and take him to the hospital, or B, she does claim that the level of the house where the fire started was where all the cell phones were, and she was not going to be able to get in touch with 911. And Todd made his way out of the house, and she accidentally ran him over because she couldn't see him. This is where we are with this, folks. I blame Michigan.
Those burn injuries.
I would assume that the burns just of themselves would be painful, and I assume that touching them or moving him would have also been painful as well.
How about laying on them?
Again,
Lack of foundation, he doesn't know what the situation was.
Outside of his area of expertise at this point, so I'll sustain.
Okay.
One hand goes beyond my cross.
The rules of evidence allow that, but I'll sustain the objection.
I have no further questions, Your Honor. Thank you.
As a medical professional, you deal in probabilities, not possibilities, don't you?
I mean, my diagnoses are usually made on some degree of probability. Many, many things are possible. I try to deal in what is most probable.
Because if you're dealing in possibilities, you're merely speculating, aren't you?
There will be no speculation with Timu Oddjob.
I mean, I guess to some extent, if it's possible, then I can't exclude it.
But it's guesswork to represent that it was something affirmatively to a jury, correct?
I mean, I don't think I've stated anything that I don't think is probable.
Not accusing you, doctor, but because you
No,
deal in
that kinda-
probabilities to say.
I mean, sir, that did kind of sound like you were accusing him of lying to the jury, that he was speculating on things that he wasn't, smart about. Also, sir, again, escaped doctor from Scrubs. Again, call me a liar, but how this man escaped Scrubs, I do not know, but he is testifying as a medical examiner today. I mean, am I lying, y'all? Because I give you... So, Jem, he was arguing about it being painful. I have no idea why, but the state did turn that around, and Linda had multiple witnesses saying that she was laying on top of Todd, she was touching him, she was trying to hug him. So, there you go. I'm telling you, this man has done a lot since Scrubs. He became a real doctor, a medical examiner. I'm not comparing him to that. What I'm comparing him to is that he looks just like him. So I would say, did you play on Scrubs, and is Zach Braff really funny?
Say it's possible it could be
And
something.
welcome Coop Raiders
and
too.
have a representation that it is
And the
that.
Billboards.
That would be misleading, wouldn't it?
But I would never say that something is definitively this just because it's possible that it's that.
Okay. Have you had any autopsies where somebody was struck by a frying pan?
I don't recall.
If you get struck by a frying pan, typically it's right.
The fuck did I just see? I'm confused. Is this a court of law? Did this man actually mimic getting hit by a frying pan with his papers, and then he did like the whole, cartoon with the little Tweety birds around? Okay, Michigan, that's it. Michigan, come to the front of the damn congregation. I need you to explain this. What the hell is going on? I mean, if we're going to demonstrate anything, I would like to see a rear naked chokehold while both of you are naked. That being said, I don't want to see y'all naked. I just, to honor the, actual language that we've all agreed on, I think that you must be naked to do a naked rear chokehold. Thank you.
I don't know, I've
JP.
never been struck by a frying
Your
pan.
Honor, he's dealing with autopsies. He's certainly not there when somebody gets struck with a pan and how it affects
You
them.
can talk about the injuries. And
That was
This
beyond
is
scope
stating
of
that
injury, Your
objection.
Honor.
This is outside of his area.
it would typically result in a skull fracture, wouldn't it?
Probably that's an overstatement. It could result in a skull fracture.
Okay. Or not.
Or not.
Thank you. No more questions.
I have no further questions, Your Honor.
Jury, do you have questions of him? Oh, yes. Oh, my gosh.
Oh, please, jurors,
Need
were
more?
you on Scrubs?
Okay.
You guys, I would ask that question. You have no idea. So I will say the jury questions have been pretty interesting, pretty on topic. It does seem like they are focusing, and I do like that. I will say that both sets of lawyers, the state and the defense, have done everything to muddy the waters for these jurors. They have not made things clear. It does seem that the jury is doing a better job of asking some pertinent questions. So let's see what they say. I only have, I think, 13 pages of notes for this case already. So, we're doing fine. We are cooking with gasoline. Now, I will say that in the intervening years, with Linda having softened and looked much older, I do think that this might help. Oh, crap. Too soon. Too soon. That being said, I have noticed that the jury questions have been pretty good. This case has been shenanigans. The opposing sides seem to just legitimately hate each other and go out of their ways to annoy each other. I've seen more kind of unprofessional objections and kind of back and forth bickering with both of these sets of attorneys. Yeah, that's speculation. There's no proof that we were cooking with gasoline. Well, they fight like siblings. I swear, this entire case has been, I'm not touching you. I'm not touching you. And then the state will be like, Mom, or the defense will be like, Mom, the judge has just about had enough of this. And Lynn Dalton says, hey, Mo, we're not as bad as Wisconsin and Massachusetts, but we get our share of dandy courtroom drama downstate. Here in the Upper Peninsula, we're pristine. And I have no room to talk. I'm from Indiana, the home of the Delphi case. So honestly, I really have no stones to throw.
Questions from the jury. Do you know the performing laboratories' cutoff levels for their test validation or their established levels of detection and level of, some of you have really bad handwriting, level of quantification for their drugs?
So the testing that was done at the time was done at a laboratory that no longer does the testing. I don't know any of the specific parameters for like the level of detection for any of the substances that they tested, nor any of the particulars regarding that. Having done this for a long time, they're generally relatively low, so I would expect that had there been something there in significant quantities, it would have been detected. But no, I can't give you, like, for hydrocodone, their level of detection was 0.5 nanogram per milliliter. I don't know those parameters.
Similar question. Do all labs use, if you know, do all labs use the same detection levels for blood and urine?
No, they do not. Typically, the detection levels are quite different for blood and urine specimens. Urine specimens usually are significantly higher concentrations, the lower concentrations, just because the drug tends to accumulate in the urine. So they generally have higher detection levels in urine. Most labs don't quantitate or give you a level in the urine, but they generally will, at least in the forensic setting, in the blood. And those detection levels may vary from laboratory to laboratory.
Old Line Red said, since I grew up about 20 minutes from this courthouse, I feel the need to say that we are not this weird, and any decent Michigander has to think all of these attorneys are rude spazzes. Okay, so it's Michigander, not Michigonian or Michiganite. I think you should think about Michiganite. It's weird to say, it's difficult, and you wouldn't feel like a goose or a gander. I'm just throwing it out there. I'm not from Michigan, so I don't have the right to, vote for a name change, but I'm just throwing it out there. Or Michigonian.
You stated that 90% of the body was severely burned with skin intact at feet and part of a leg. I'm curious how a fingerprint can be taken when skin is burned off or sloughed off. Please further explain.
Yeah, he had burns to his hands. The skin actually was mostly sloughing off of the hands. So with burns, a lot of times the outer layers of the skin separate from the inner layers. And in this case, it wasn't present. You couldn't see it in the photographs, but there was still skin on the fingers. It basically was just sort of sloughed off, like if you were wearing a latex glove and you pulled it off. it was still there, but it really wasn't in place where it normally should be any longer on the hand. So in many cases, we are still able to get fingerprints in bodies that are burned, as long as the hands themselves aren't completely, the skin isn't completely burned off. In this case, the skin was more sloughed off of the hands than burned.
Okay. And there was one question, jury, that I'm not going to be asking. I've determined under the law not to ask it. Could lacerations be sustained from a fall or from a fall on stairs?
In this specific case or in general?
My guess is, how about both?
Okay. In general, yes, lacerations can occur anytime there's an impact. So if you fall downstairs and you strike your head on the wall, on a railing, on the floor, yes, you could get lacerations. I think, as I've stated before, I can't tell exactly what caused these lacerations. So, could one of the lacerations or more of the lacerations be from falling downstairs? I couldn't exclude that.
Thank you. If blunt injuries were possibly caused by the van, would the amount of blood on the van be there as soon as the body was impacted, in your professional opinion?
Typically, blood is transferred at the time of an injury. So, if you're struck by something and it causes a laceration of the skin, that generally you're going to bleed, and there will probably be blood on the impacting surface. So if you fall and hit your head on, the corner of a table, there's likely going to be blood on the corner of the table. There may be a lot more, on the ground after you fall and bleed. But yes, there would likely be blood on an impacting surface.
Thank you. Is there...
Okay, old line read. About 80% of Michigan residents identify as Michiganders. Editorial style books use Michiganian. It is somewhat a touchy issue. The legislator has voted to change it to Michigander, to no avail. And welcome Wednesday.
Is there any testing of the surface of the skin to determine if there is anything, in parentheses, substance, on the skin? And also, did you receive any documentation in regards to Todd Stermer's pants or lack of pants?
I guess the question is, like, what sort of substance? Our laboratory testing of the body is usually body fluids, and they're usually being analyzed for medications, drugs, that sort of stuff. I can't test, like, the body surface, for example, for an accelerant. That's out of sort of my area of purview, if you will, when doing an autopsy. And what was the second part? Sorry.
Oh, it had to do with Todd Stermer. Here we go. Did you receive any documentation in regards to Todd Stermer's pants or lack of?
Not that I recall.
Okay. Counsel, any questions in light of those questions and answers?
No, Your Honor.
Mr. Mueller?
Yes, just a few. There was a question about if you fell down the stairs, could you get these lacerations? You had 4 different lacerations in 4 different spots on the head. You with me?
Yes.
That wouldn't be consistent with a fall down the stairs as compared to being under the undercarriage of a van, as you saw those pictures.
Wait, defense, are you arguing that this man didn't fall down the stairs, that your client ran him over with a van? Because I thought you were for the defense. You are working for the defense, right? Do what now?
With the blood.
Well, again, it all depends. I mean, if you fall down the stairs and, you fall down 20 stairs and you hit stair number 4 on one side of your head and you hit stair number 12 on the top of your head as you're tumbling down, you may have more than one impact site. What we're talking.
Is this some kind of reverse Jedi? Like, these are not the droids you're looking for? Like, This is not the van that ran him over. He fell down the stairs. And for those of you that are just coming in, I'll do a brief little, blurb about this case. So this is Michigan versus Linda Stermer. It is a retrial. We are currently on day 2 towards the tail end of it. There was supposed to be day 3 today, but I think it got canceled for something. The state contends that Linda Stermer bludgeoned, set on fire, and then ran over her husband, Todd Stermer. Now, there is the fact that she was in a relationship with someone else, and there were financial issues to the point that even the home insurance policy had not been paid up at the time of the fire. Now, in the history of never have I ever heard of an insurance doing this, but they simply told Linda after the fire to go pay the balance off at the courthouse, and then they would consider her covered for the fire. I have never heard of insurance being kind and giving you like a back date on your, policy. That being said, she was initially convicted in 2010. This happened in 2007. Her conviction was overturned in 2018. I do have the order now, so I will be going over that later. But it basically was for, ineffective assistance of counsel, and the fact that her counsel did not retain any sort of experts to, negate the state's experts. So she was given a retrial. She has been out on an ankle monitor in the intervening time, and this is the retrial. Now, the state has today, or at least on day 2, lost one of their experts because apparently in the intervening, 18 years since this case has, started, they lost some of the paperwork or the gas spectrometry like graphs. So it looks like, that information has been lost, so that expert could not testify because he had lost the evidence for which he was going to try to testify. So both the state and the defense, I think, have had missteps. The defense's opening is something of legend. I would say the only way to watch the state's opening or the defense's opening is to watch it from Legal Shenanigans Theater on Saturday. Veilhammer and I went through the opening statement for the defense, and I can only say that he Shatnered the ever-living heck out of it. And that's not a good thing. If you're a defense attorney, the pregnant pauses were themselves double pregnant.
Talking about are, lacerations that are very distinct from each other are indicating, different impacts. So anything in which you could potentially sustain multiple impacts could result in you having 4 lacerations on your head, whether that being falling down multiple stairs, or being hit multiple times in the head with something, or being run over by a vehicle and hitting multiple parts of the undercarriage of a vehicle. There's nothing about them specifically that allows me to say I know what specifically caused them.
Okay. Something along the lines of 20 stairs, you said?
I have no idea. I'm just saying that you would have to have 4 impacts with something, either the stairs, the wall, something.
Again, that's a possibility, correct?
Yes, just like the other scenarios I gave are possibilities.
Thank you.
Also a possibility, it could have been a combination of all of those things, is that correct?
Right, I can't say that they're not from more than one.
And there's a possibility that one day I'll wake up with a 6-pack abs and my boobs back to where they were when I was 18. But I'm not going to wake up every morning, expecting, the nipular region of my boobs to be back where it was when I was 18. I mean, I wish it would happen. Tiny baby Jeebus, if you're listening. That being said, these hypothetical questions are going to drive me nuts.
One event or more than one object.
No further questions.
Jury, any more questions? Okay, we've got one more, it looks like. try it again. Is it possible for a drug to be present but below the level of detection?
Yes, as I stated before, a negative result just means that the drug is below the level of detection. So if it's not there at all, then it would be negative and it wouldn't be reported. If it's at such a low concentration that it doesn't reach the minimum level of detection, then it would also be reported as negative in that instance.
Any questions from you two?
Let me get this right. If it's below the level of detection, and you said they're low thresholds, right, for the blood?
Generally, yes.
Okay. Below the level of detection, it could be 0, there's nothing in there, right?
That is correct. It could mean that the drug just isn't there.
Or it could just simply be below that low threshold, that sensitive threshold to detect, fair?
Heather May, so I know Indiana and Michigan do. I want to say that there's a couple other states. Now, Indiana, where I live, is different from all the rest of the states in that we allow jury questions. Also, we allow the jury to start deliberating as long as they are all comfortable with it throughout the trial. So most of the times, and I think every other jury is told not to start discussing the case prior to deliberation. And Florida does jury questions. I knew there was one. So Indiana is the only state that I know that does that particular jury shenanigans. But there are several states that do allow questions of the jury.
That is correct.
Either way, in this case, it was not in his system, correct?
There was nothing detectable other than caffeine in his system.
Thank you. I wouldn't want anybody to detect my caffeine level.
No, you're not. I have no question.
Oh, you made it funny.
Going once.
I can't remember. I need to go back and do a rewatch of the Letitia Stalk trial. Hopefully with spring coming, I'm going to start, that's what she said, giggity. But hopefully I will start feeling a little better and be able to do more stuff. I am not kidding you guys when I say that this has been the worst winter I have ever experienced since having CRPS. That being said, look, I don't look good in orange, but if Puxatawny Phil says we're having 6 more weeks of winter...
odor, and how would you describe it?
I'm not saying that I have a crack group of people with chronic pain and a Econo liner van. And look, we're not going to do anything mean to Puxatawny Phil, but we are going to encourage him to come out of his shell and, enjoy the sunshine. Because I have it on firm, recognizance that we are all done with winter. Winter has been some bullshit, so we're done. We RSVP no for that. We gave it up for Lent. We are done.
At the time I do the autopsy, it doesn't generally have much of an odor in most instances. In bodies that are severely burned, I mean like charred to the point where they look not even like human bodies anymore, then they do have a smell, and it smells, unfortunately, like something most of you have probably experienced, which is, burnt flesh from animals, what we would call meat.
Damn it, this man has just ruined barbecues for now all of the jury. Well, I know an entire, 12 people that won't be having 4th of July barbecues now. You have ruined the economy. Thank you. Now when, the consumer price index does that, your 4th of July picnic can, only be had for this amount of money. I mean, he did have the decency to look a little, chagrined about the whole thing, but damn, now I'm never going to be able to have barbecue again.
So, unfortunately, fortunately he wasn't burned to that extent, but in more severe cases, it does have a smell of essentially burning meat or burning flesh.
Counsel, any questions in light of that?
I'm going straight to hell for this one, so that means he was original recipe, not extra crispy. I'll be taking myself to hell now. No one has to... No one... Look, don't send the demons out, you know, Satan. I will take myself to jail.
I just would ask, would your body fluids have more of a smell as you're burning? You talked about how the outer layer skin's coming off and the fluids are seeping out.
I mean, at autopsy, unless they're severely burned and charred, I don't usually notice like a distinctive smell just from a body that was...
This leads me to another question. Doctor, do you smell all the patients as they come in? I mean, I feel this leads us to deeper questions that I want answered. Do you sniff every patient? Do you like to sniff every patient? Is this a part of your, you know, routine? I have so many more questions than answers now.
Burned, like in this case.
So by the time you get the body, you wouldn't even have any detection, even on a less severe burn.
Like I stated, on a severely burned, charred body, when we open the body bag, they generally smell like, you know, you've burnt something on your grill.
Well, I mean, Jedi, you're a Jedi, so I didn't assume you had a, you know, hand in the arson. I assumed that maybe you had, you know, maybe, oh gosh, was it represented a client in some sort of, you know, I don't know. Yeah, Heather May, I wish we could stop going down this line of questioning. I think that they have gotten everything out of this man that they're going to get. He can't tell you absolutely what happened. He has told you that they don't do testing for accelerants. But really, all of this that he's talking about now are hypotheticals.
If they're not to that point, then typically I've not recognized a distinctive odor.
Thank you. I have no further questions.
Oh, no.
No questions.
Any other questions, jury? Yep. Go ahead. Question?
Sorry.
That's okay. Yes, there is.
Oh, there's another juror question. Damn. This man is never getting off the...
Contribute to detectable level. Jury, no objection from counsel. Can loss of blood contribute to detectable levels?
Generally not. As long as we have enough blood to submit, since it's a concentration and amount per the amount of blood that you have, it doesn't generally affect our ability to detect drugs.
I will say that is a very good question, though, because it would be a question that if you didn't know medicine, if you didn't understand that they kind of titrate or quantitate, you know, for the amount of blood, you know, parts per million. I will say that this is a very good question. I mean, you know, the jury has heard, so that means they're paying attention because they've heard that he's lost fluid. They've learned that it, you know, can lead to circulation issues. So this is encouraging that the jury is taking in and really thinking critically about all of the information.
So, you know, a normal human body probably has, you know, a few liters of blood. What we submit for testing is generally, you know, a few milliliters, and what they actually test is oftentimes even a smaller amount than that. So generally, the drug is fairly uniformly distributed throughout your blood, and what I get is a concentration. So whether they analyze, you know, 4 milliliters of blood or you know, 1 milliliter of blood, it should give the same relative concentration.
Okay. Any follow-up, counsel?
No, Your Honor.
None, Your Honor.
Any other questions, jury? No? May he be excused from his subpoena, counsel?
Please be excused, Your Honor.
Thank you, Doctor.
Thank you,
He's
sir.
like, for the love of
Oh, wait,
Tony.
one more question. If you could hand me the exhibits, and I'll take care of this. Is that yours? Okay, thank you. Siderling, did you want to take a break now, or?
That sounds great.
Okay, so jury, we'll take a 15-minute break before the next witness.
And we will not be going on that break with them. There's Mises and, circumspect or circumspice. Must look up what circumspice means.
Is that coming up next?
No, Amy,
So this is Sarah. Linda told multiple stories about what Todd was doing in the room when it was set ablaze, or it combusted. It started on fire. One time she said that maybe the fire could have been caused because, Todd was up there smoking the ganja. Now, she also then said that he was asleep. She's made different kind of claims as to what he was doing. So she has sort of blamed it on the ganja and not in dueling sort of narratives. She has changed kind of what was going on, different details. Now, one thing that does maintain consistency in a lot of her stories is that she was in the basement doing laundry when this conflagration started.
Oh, she'll be short, and he'll be right after that.
Yes.
What is this, a transcript that's being read by someone?
Well, I have a transcript that was taken by Judge Shinsky as part of the fire investigation. It's all recorded, and so what he did is then he had it transcribed and then checked the transcript for accuracy against the recorded interview. So at the first trial, it was admitted in its entirety as an exhibit, the whole transcript of her interview, and we were intending to do the same.
So you're familiar with it? Here's what it is. Here's what it looks like.
The draft?
Yeah.
So there's a concern about it being called draft?
It's a draft, and we don't know who did it. It's certainly not a court reporter.
Our fine ours doesn't say draft, it's the original exhibit from the trial.
You have the original?
This one here was marked as exhibit number 13.
Well, and Heather May, so let's see, in Canada, it seems very limited if jurors can ask questions of witnesses. It must be approved by the judge first. So I do believe that it's kind of legislated here as to whether you're allowed to do it. But then I think it can also be for judge comfort, and the judge does have to approve, along with the lawyers, these questions. The jury isn't allowed to ask, BS questions like, do these attorneys annoy you? That wouldn't go through. But they do have to, make sure it's within the purview of what they can be legally asked, the evidence that's been, included, and that kind of thing. There were a lot of times in other cases where jurors were allowed to ask questions that a judge would have to say, hey, you can ask this question, but not of this witness, or this isn't the witness that you're going to, you can ask that question to. So while the judge doesn't tell the jury what they can ask, they might give hints as to, okay, well, this is a good question, but it's not the correct witness.
On January 6, 2010.
No, well, I have one here that doesn't say draft, and he'll testify as to the accuracy.
Okay. So do you want her to provide you the one that doesn't say draft?
Yes.
Okay. I guess my staff can make copies to keep things moving.
Here, I've got it. You want to email it to you, or?
Have somebody run a copy and give it to me by the end of the day.
Yeah, I have an electronic copy on a flash drive I can send right now.
Okay.
If you want a photo digital copy of a hard copy, I can have some print off downstairs.
Mr. Mueller, did you want a piece? I heard you say end of the day, but I couldn't hear what you said otherwise.
I want a hard copy today.
By the end of the day.
Just give us a few minutes, we'll hand it to him.
Okay. Anything else on that matter before I bring in the jury? Okay. Bring in the jury.
I actually just looked at the time, you guys. We're going to get about 15 minutes into this next witness, and then I will have to bail to go get the youngmost feral, and I will finish up the end of today, probably this evening, and then I might read a bit of the, appeal that Linda and her attorneys put in. It is quite long. In fact, let's see, it is 100. Oh, no. Okay, wait. So for the appeal document, it looks like it is 239 pages. So I will be reading her motion. That's about 83 pages. It's going to be a longer video, possibly. But then I have got Awesome Possum. Oh, it looks like I've got Sarah Boone documents on the way.
You may call your next witness.
Your Honor, could you call Amy Darling to the stand, please?
Amy Darling, Wendy's sister that wasn't kidnapped by Peter Pan.
And before you have a seat, I'll have you pause and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Yes. Thank you. Please have a seat, and when you're settled, we'll have you give us your full name and spell the last, please.
My name is Amy Elizabeth Darling, D-A-R-L-I-N-G.
If you can move that microphone up a little bit closer so the jury can hear you. Thank you. Ms. Ivy?
Thank you.
Okay, I already love her. She does the crazy face thing. The like, I'm in love. We are best friends now. Look, she's like, I don't want to make an ass out of myself. And then she, does the little microphone. So she already has a VIP ticket to the Petty Express because, look, she does the crazy face thing.
Your Honor. Ms. Darling, what is your current occupation?
My current occupation is drug command program manager.
And how long have you been in that position?
I have been almost 3.5 years.
And what did you do prior?
Prior to that, I was a 911 dispatcher for Michigan State Police.
How long did you do that?
Almost 18 years.
18 years. And at any point were you then also the medical examiner?
I was.
What years were you the medical examiner?
From 2000 until 2000, my apologies, 2022.
So you do that in conjunction with your other occupations?
I did.
And can you explain to the jury what a medical examiner is?
Medical examiner investigator is a person who goes out and any unattended death in the county that I resided in, which was Van Buren County, is investigated. Findings are then taken to a medical examiner or to their primary doctor to determine cause of death.
So you assist on scene, is that correct?
Yes, ma'am.
And you're called out on all deaths?
Any unattended death, correct.
What's unattended death mean?
Unattended death is any unwitnessed death by a physician.
So for example, if a physician has somebody with a heart attack in the hospital, you don't have to go there?
Correct.
This would be just anything out in the community that a law enforcement person would call you and say that a doctor didn't witness this?
Law enforcement, emergency services, for ambulance services, first responders.
Okay, perfect. And as part of your position as a medical examiner investigator, were you called out to the scene on January 7th of 2007 to the Todd Stermer home?
I was.
Do you recall approximately what time of day you went out there?
Approximately 16:30.
So 16:30.
So 4:30 for those of you who don't understand military time.
In military time
My
is
apologies, it's 4:30 p.m.
4:30 p.m. Perfect. And so do you remember what you did when you first arrived?
I did.
And what did you do?
I went up, I made contact with the law enforcement that was on scene and the EMS personnel that was still on scene with the decedent.
And did you drive down the driveway?
That I do not recall.
So once you got to the residence, you made contact with who?
the law enforcement and the ambulance personnel that was on scene.
And do you recall approximately how many people were on scene at that time?
No, ma'am, I do not.
Was it chaotic, or were a small number of people?
It was pretty chaotic. Law enforcement was there, fire department was still there, emergency medical services were still on scene.
So all of the ambulance, fire department, police, everybody was still there?
Yes, ma'am.
Okay. And what did you do then when you arrived?
I took custody of the body from the ambulance personnel and received reports from them about their attempts and attempts to resuscitate Mr. Stermer.
So you spent time talking to people on scene about the attempts?
Correct.
And what attempts were you aware of at that time?
Time you have in mountains?
The ambulance scene performed advanced cardiac life support, which involved trying to establish an airway, trying to restart his heart, both by electric mechanisms and by performing cardiopulmonary resuscitation.
So once you were advised then of all these attempts, then what was your next action?
My next action was to examine the body.
And where was the body?
I'm sorry?
What the body?
Examine the body.
And where was the body when you had the opportunity to examine it?
The body was out on the ground, away from the house a little ways.
So still on location on the ground?
On location on the ground.
And what did you observe when you examined the body?
First observation, it was that there was a figure underneath blankets. Blankets were removed to find a couple jackets that were laid over the decedent. Those were removed. Find a white male that is sustained burns all over his body to the point where his skin was sloughing off and his fingers were degloving. There were signs of medical resuscitation efforts, including defibrillator patches. There were burn singe marks all over his body that were still contained skin slippage, which means that the skin was falling off of the body itself. The male had burnt, singed skin up around his face. His hair was down to stubs, both around the facial area and throughout his head, where normal hair growth would have been. It was unknown if that was his haircut or if it was from the burning. The decedent also had dirt that was on his knees and shins that was caked into the grooves in his knees. He was found to have a laceration on the back of his head that was open and substantial burns on the left shoulder with an open laceration on his bicep area.
Was there any bleeding at that time?
Yes, ma'am. It was prevalent of the seepage. It's not.
J.K.D. Buck, then I wouldn't watch the rest of this trial, or this part of the trial, because I think they're going to talk about degloving as well. So, you know your stomach. I would probably pass on this part of the trial if I were just going to eat lunch, or just having eaten lunch, but...
necessarily bleeding when they're deceased at that time.
So, okay, so you had seen the seepage. Was there blood present on the scene with the body?
The body had been moved prior to my arrival. The first responders, after I did my examination and readied the body for transport and secured it, talked to the investigators that were first on the scene and our resuscitation efforts. They actually moved the body away from the burning structure prior and relocated it. So there was no pooling of blood or bodily fluids at the location where the decedent was found.
And at that time that you arrived, was there any heartbeat?
No, ma'am.
Any pulse?
No, ma'am.
And did you pronounce him dead on that scene?
I did not. The paramedics that were on scene called Lakeview Hospital, and they established the time of death as 16:17.
And once that time of death was established, what's your role?
My protocol is that I'm called out after that is determined.
I apologize. So that actually happens first?
Yes, ma'am.
And so after you've had the opportunity then to examine the body, what's the next steps that you take?
Then I talk to the personnel on scene, trying to get as much information about how the body came to be in its location, information about it, who the responders were on scene that I could ascertain. Then the body is then secured in a body bag, and at this time, the medical examiner had determined that it definitely needed to go for an autopsy. So the body bag was secured in that fashion. The zippers were tied, and it was sent with Calvin Funeral Home to Sparrow for autopsy.
So you say that the body bag was secured and tied. Can you explain to the jury what that means?
Secured and tied means instead of placing a security device on one zipper where it would contain the name and possibly, if we had at the time, the case number for the decedent, the zippers are actually put together and tied together. And then the decedent's identification information is added onto that.
Okay, does she remind anyone of Drew Barrymore? Like maybe in the mouthular area, maybe it's the kind of turned down mouth, I don't know. But she reminds me of Drew Barrymore, although she's not trying to touch people randomly. So.
Does that have to be clipped with a tool then to be able to be opened?
It has to be clipped in order to move the zippers.
So not something that somebody could readily just open?
Correct.
And there'd be evidence then if somebody were to break into that?
Correct, because the name tag would not stay attached to that zipper that way, the way that it's secured.
Did you also take photos then of the body?
I did not.
You did not. Do you know who did?
I believe the sheriff's department, but I'm not for sure.
Were you present when they were taking the photos?
No, ma'am, I was not.
Okay. And you mentioned that there were several articles of like clothing laid on the decedent?
Yes, ma'am.
And what is done with those items?
So the articles that were covering the decedent's, most of his body,
Well, Alex muted. What I will say is I think Drew Barrymore has her own show, and I've never watched it fully. I've watched clips, and she's always like sitting really close to the person that she's interviewing and like holding their hand as she's deeply looking into their eyes. Which are things that all introverts and people with social anxiety tend to trip out about. So I tend to notice it more than, say, the average bear, mostly because all of those things sound like hell no to me. That being said, you know, I tend to be, you know, kind of a personal bubble kind of person. I don't tend to be a touchy-feely kind of person. But I am going to let you guys go from here. I do have to go pick up the youngest, most ferals, and then I will be starting probably around 6 or 7 with the last little bit of today. It looks like we have, you know, Amy Darling and then James Shinsky, who looks like he has a hole in his head. That is a terrible hairdo. But he looks like the fire investigator. So we will be all caught up, hopefully, in theory. As always, you know, being caught up is theoretical in, you know, on the Petty Express. All things are all, you know, forward plannings are, you know, theoretical in Mo's world. And I am going to send you guys over to Recovery Attic. I let him know I sent you, give him, you know, likes and all of the, you know, energons as I run out of here. Thank you all so much for joining. And I will be doing breakdowns of day 1 and day 2 in short video form. If you want to join up tomorrow and be sort of caught up, I will have videos for those, or at least kind of showcasing and breaking down the case thus far. Either up tonight or tomorrow, in theory. I will see you guys all probably tonight and definitely tomorrow mornings for Mornings with Mo, the source for all the news you never knew you always needed. Bye, you guys.